For reasons mentioned in the order, this interlocutory application is dismissed. Because of that.
46 form supplementary.
For reasons mentioned in the order, this court is of considered opinion that there is no bar in Shri Devajit Saikya, learned senior counsel, appearing for the petitioner in this case as senior advocate, while he continues to hold the post of Advocate General. Stop. For reasons mentioned in the order, the petitioner is entitled to get bail in this case. Accordingly, he is allowed to go on bail of rupees 1 lakh with one surety of like amount, subject to certain conditions.
Item number 21 with consent of other side, it may come up after 2 weeks.
Heard Mr. Injay Das, learned counsel for the petitioner who seeks an adjournment on the ground of personal difficulty, his personal difficulty. Who is for the other side? Also, Mr. P. Chaudhary, learned counsel for the respondent who does not have any. Who is standing counsel PNB?
I am for PNB.
Okay. Who does not have any objection to the prayer made by the learned counsel for the petitioner. Hence, the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Right. Interim order may continue.
The interim order shall continue till next.
Bless. Problem.
So I'm praying for listing a anticipatory bill tomorrow, Lordship. I filed before yesterday, Lordship. Praying for listing tomorrow.
Tomorrow,
Friday. When did file, Lordship?
Monday.
Monday.
Wait, Lordship, I have to mention item number 25, Lordship. There are certain developments is going on, Lordship, in this case, Lordship, and accordingly, I am praying for listing of this matter in the next week, except 15 September, Lordship. Item number 25.
Heard Miss N. Chaudhary, learned counsel for the petitioner who prays for an adjournment on the ground that certain on the ground, don't mention the ground. Prayed for an adjournment. The prayer is allowed. Let this matter be listed in the. Also heard Mr. K.K. Parashar, learned additional public prosecutor who submits that the case diary is available. Let this matter be listed on.
Can it be on 17 or 18? 17.
17th of September. The case diary shall be retained till next day.
Is the Lordship, in item number 38, we have filed an additional affidavit, Your Lordship. Kindly call for the records.
Call for the additional affidavit. Item number 38.
Please, Your Lordship. I beg to mention item number 50, the read list, Your Lordship. Lordship, matter will be adjourned for a week, Your Lordship. 1/5,
1, 5 or 5?
1/5, 15.
Heard Mr.
T. Chetri.
P. Chetri, learned counsel for the petitioner who prays for an adjournment. On what ground?
Mr. Ganguly has some personal difficulty.
On the ground of personal difficulty of the conducting counsel. The prayer is allowed. Let this matter be listed in the next week on a date to be fixed by registry.
Much
Hello,
obliged.
Mr. Lordship, I beg to mention an anticipatory bail for listing. Lordship, the accused is a 19-year-old boy, Lordship.
When have you filed?
Yesterday, Lordship.
It will come on Monday.
Actually, yesterday I already tried to mention it. The Lordship asked me to mention it today as I have filed it yesterday, Lordship.
No, you have to wait till for 2 days.
Lordship, the accused will appear before the Karnataka police on Monday, Lordship. That is 0809/2025. Lordship, he might get arrested at any time, Lordship. So,
You will go to Karnataka on Monday?
yes, Sir, Lordship.
Okay. Tomorrow.
Much obliged.
May please, Lordship, I beg to mention item number 11 for withdraw the matter, Lordship.
What is your name?
A Huda.
Heard Mr. A.
Lordship,
Huda.
kindly allow me to file a case with liberty, Lordship.
No liberty is required. Heard Mr. A. Huda, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant anticipatory bail. The prayer is allowed. This bail, anticipatory bail application is dismissed on withdrawal.
Obliged.
Yeah, please, your Lordship, I beg to mention item number 48. Lordship, we have filed our objection. 48.
48.
Our objection may be called for.
Call for the objection.
Highly obliged. May I please, your Lordship, I beg to mention for listing of an anticipatory bail, your Lordship,
When have you filed?
on 2nd of September, your Lordship, 2 days back.
On Monday.
Lordship, tomorrow.
What is the urgency?
Lordship, he may be arrested, that's it.
On Monday, Tuesday.
Monday,
Okay,
Monday.
Monday.
My lord, this is my lord commercial quantity, my lord, so my lord CD may kindly be called for.
Heard Mr. M.U. Mandal, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Call for the case diary.
18-9, my lord.
24. 18, we have many cases running. 24/9.
Along with my lord FSL report.
Whatever is there in the case diary, it will come.
Obliged.
May I please, your Lordship? Intermediate quantity, Lordship, LCR may be called for, charge-sheeted matter.
Heard Mr. M.R. Sodior, learned counsel for the petitioner. Also heard Ms. Indas. Call for the scanned copy of the trial court records. Registry to issue the requisition for the same. Let this matter be on 22nd of September.
Deeply obliged.
Item 4.
My lord, 482 bail petition, my lord, FIR in case 22, my lord.
Also, Lordship.
Oxo is there.
Yes, my lord, Lordship, for a moment, my lord, Lordship, come to place 22, my lord.
No, what is,
My lord, actually the petitioner number 1 and the alleged victim, who is presently 19 years, my lord, who she herself lost this affair, my lord. She is stating a incident which was took place about the 2 years, 7 months ago, my lord, against his husband, my lord, and his father-in-law. Case 22, my lord.
then why trial court rejected your bail?
My lord, only based upon the FIR, my lord, a rejection order in the case.
After perusal of the case diary?
Yes, my lord, rejected.
Chargesheet has been laid or not?
No, my lord.
So case diary has to. Heard Mr. K. M. Hassan, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. Call for the case diary. Issue notice to respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice upon respondent number 2 within 3 days from the date of this order, returnable on 19th of September.
My lord, obligation.
Item 5. My lord, NDPS notice and CD will
Heard
review.
Mr. A. Paramanik, learned counsel for the petitioner. Also heard Ms. N. Das, call for the case diary, issue notice to respondent number 2, fix 19,
Highly.
Abhishek. Or earlier order, copy earlier.
Wait, please, your lordship. Lordship, this is a regular bail application, although the FOXO is there, lordship, can it peruse the FIR first, lordship?
Why your pair was rejected by the trial court?
Prayer was my lordship, kindly allow me to read the FIR first.
No,
We
first you tell me,
Because of that, lordship, the rejection order, lordship will find that we have raised that, lordship, ground of arrest has not been mentioned, lordship. That
where is the rejection order?
rejection order, lordship, will find on page 18, page 26, lordship. One AI generated photo, lordship, circulated from one accused, lordship, Choinika Das, not from us, lordship. We are in the same WhatsApp group, lordship. That is the allegation against this lordship petitioner. They are in the group and it is received from Choinika Das, lordship. That's why, lordship, I'm insisting court to, lordship, go peruse the FIR, lordship.
No, but you took these pleas before trial court also.
Yes, lordship.
Why it
The-
rejected?
Rejected, that is their lordship on page 28, lordship.
Insufficient informative materials against the accused persons.
But it is specific that it is received from Choinika Das, one of the WhatsApp group member. I'm not for that Choinika Das.
Case diary would be required. Heard,
Otherwise, 48 days in jail, lordship. It's a case of lordship 60 days and lordship 35 3 notice was not
we
issued.
are fixing short date. Heard Mr. B. Chaudhary, learned counsel for the petitioner. Also heard Ms. N. Das, give a short date. Call for the case diary, list this matter on 10.
Obligation.
Item 7.
May I please, your lordship? Chargesheet, my also matter, my lord.
Heard Mr. D. Bora, learned counsel for the petitioner. Also heard Ms. N. Das, call for the trial court records. Issue notice to respondent number 2. Let this matter be listed 18th of September. Steps, also steps within 3 days in accordance with the prevailing notice.
Arrested by lordship, FIR on page 8, lordship. Regarding his allegation is that he have got a cow slaughterhouse, lordship. There is the allegation, but while raid was done, lordship, no beef has been recovered from that part, lordship. That page 8 is there. Earlier he was involved in this, lordship. When it was banned, lordship, he have left that job, lordship, totally.
We'll call for the case. diary.
Lordship, will kindly see the allegation, lordship. No beef has been recovered.
Why the prayer was rejected?
The prayer was rejected, lordship, because of the allegation, lordship. It was very initial, it's a very fast day, lordship.
Let us go. Show me the-
Lordship, can you see the FIR, lordship? Absolutely, further custodial might not be required. I admit that, lordship, he was doing that, lordship, prior to the law has been banned, lordship. That slaughter was banned, lordship. Initially, have done, lordship, nothing, lordship, no blood has been, there nothing, lordship. No beef has been recovered.
Where is,
Lordship, house was-
where is the rejection order?
Rejection order, lordship, will find on page 15, lordship. That 28/8/2000 accused, namely so and so, produced before me, arrested by IO concern of the DPS connection with the incident. Scenes and peruse the grounds is arrested. Arrest narrated in the forwarding report and arrest memo as well as inspection memo, notice so and so, and the medical report of the accused. The further perusal of the notice of information under 47 is grounds of arrest has been communicated accused so and so, and heard the accused person here stated that he has no injury, but he was diagnosed with kidney stone. That a part of his family member are aware of his arrest. The accused person has stated that he engaged counsel so and so. Accordingly, learned so and so has represented the filed a petition under one they were praying the granting bail to the accused. Heard both has seen and perused the FIR along with forwarding. The accused has been arrested on so and so and been booked under so and so. Hence, the incident is very nascent stage of the investigation as well as section 13(1), and the incident is punishable to up to 8 years And accordingly, the honorable lordship tribal by the honorable session.
Where
That
is
was
the, where is the FIR?
FI lordship. And further, he was directed to go under medical treatment also, lordship. That FI page 8, lordship. With reference to subject cited about, I have the honor to state that based on secret information regarding illegal clause slaughtering self along with a team comprising of one so-and-so left around 5:30 p.m. conducted a raid within the residence of the person identified Imran Ali, so-and-so, son of, while conducting the raid, an illegal slaughterhouse, that I admit, was found along with sharp weapon, knives.
We are fixing shop. Yes,
Lordship,
please.
can you see, Lordship? Absolutely, Lordship. See the region of the investigation, Lordship, what it says, Lordship. There is the Lordship, nothing has been, no blood stain, nothing has been recovered. I admit that I had, Lordship, but when it was banned, thereafter I have left completely, Lordship. See the inquiry report, Lordship, that page 9 down. More of the culprit found illegal running without any authorized duly licensed certificate veterinary, and also such documents were produced by the owner. And it is conspiracy provoked in a country where cows were considered sacred by Hindu communities. They spark of the widespread anger among Hindu community and believe it liberty infame religious sentiment, and accordingly has been.
We are fixing short day.
Finally, already 8 days has been done.
Heard Mr. S. Muni, learned counsel for the petitioner. Also heard Ms. Endas. Call for the case then 9th.
Much obliged.
Much.
Item 9.
Yes. Lordship, 3 accused out of the same FIR, Lordship. 2 accused during at the time of during the course of investigation. 3 of all of them came together before Lordship. During the course of investigation, it was rejected at that stage, Lordship. After filing laying down of Chargesheet, Lordship, 2 accused Kusuri Rafa and Sabiri Rafa, they approached this honorable court and they were granted bail primarily on the ground of non-furnishing of the grounds of arrest, Lordship. And this applicant, Baliram Lava, he preferred a separate application, Lordship. But in fact, his these grounds were not taken in the earlier bail application, Lordship. It was decided and rejected on merit, Lordship. So, Lordship, out of the same FIR, Lordship, same material, same in the same NDPS sessions cases trial is going on, Lordship. So I'm filing this application afresh, Lordship, taking the grounds of non-furnishing of grounds of arrest, Lordship, and also the parity, Lordship, because all the accused out of the same FIR, Lordship, trial is also proceeding out of the same materials, Lordship. Altogether, 5 witnesses has already been examined by this time, Lordship. And the earlier rejection order of this.
Where is the rejection order?
Rejection order is at page 53, Lordship. Some procedural lapses were highlighted during the course of argument in the earlier bail application, Lordship, and the non-furnishing of grounds of arrest. This plea was not taken, Lordship, earlier. The other 2 accused, Pusuri Rafa and Sabari Rafa, they were granted bail on the same day.
Now, why you have not taken that?
Lordship, I was not the earlier engaged counsel earlier, Lordship. It was moved by
No,
different set of counsel, Lordship. And
When a plea was available, but it was not
it
taken.
was not taken, Lordship. But this time we have taken, Lordship. We have annexed the document also, Lordship.
Yes,
Page number 23, 24. Lordship.
yes.
Lordship, earlier rejected by this honorable court, and as Lordship, para 11 of rejection order, Lordship. That there is no violation of the mandatory provision of section 52A. In this case, we submit that veracity of the pleas raised by the petitioner in this case can be determined on.
We are calling scan copy of the.
Lordship, the scan copy perhaps was called during the course of hearing of the earlier bail application. It may be available with the registry, Lordship.
When the bail application was rejected.
9/6/2025. Thereafter, only one accused has been, only one witness was examined. We have
Heard Mr. D. Das, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner Baliram Rabha, mainly on the grounds of violation of the mandatory requirement of communicating the grounds of arrest at the time of his arrest. He has earlier approached this court and his prayer was rejected by order dated
9/6/25.
order dated 9/6/2025. Asked in bail application number 1071/2025. Learned counsel for the petitioner submits that in the earlier application moved by the present petitioner, he had not taken the grounds which he has agitated in the instant, in the present case. Stop. Perusal of the scanned copy of the case diary would be necessary. Learned counsel for the petitioner submits that the scanned copy of the records, trial court records were called for in connection with bail application number 1071/2025 and same might be available in the with the registry. Hence, he prays for calling of the records of bail application number 1071/2025. The prayer is allowed. Let the records of bail application number 1071/2025 be called for, along with this scan copy received in that case. Let this matter be listed on 15.
Can it be on 8 or 10? It is already available in the.
No, it is not question of availability. It's question of our number of cases we are fixing.
Next date is fixed on 11 lots, so that's why I'm insisting lots. Can it be on 10th lots?
Or 10.
I think 47 from supplementary is.
None has appeared for the petitioner on call. List this matter. They are on Monday, Tuesday, on 8th.
Maybe I can take.
The old matter, my lord, 2007, my lord, Ejahat, my lord. This case, my lord, Biswajit Roy, known to him, my lord, he was the leader of Coast Rajvanshi, my lord. Along with him, several persons were implicated here, my lord, regarding my burning of a bus, my lord. Thereafter, one person also, my lord, expired there, my lord. And Chargesheet submitted, my lord, in the year 2024, my lord.
Chargesheet submitted.
Submitted, my lord. In the lower court date is giving. It Chargesheet accepted, my lord, 10/1/2024, and Annexure 3, page 43. He also appeared there, my lord.
Then
Appeared there, but taking time by through learned and guest counsel. But his apprehension is that if he appear there, my lord, thereafter S302 is added here. He has no direct involvement here, my lord. Next date is also fixed, my lord. My lord, 10/1/24 date, Annexure 3, page 42. Kindly perusal first date. Not abscond. They give step.
no, if you have appeared, then where is the?
I have not
apprehension?
personally appeared. I took steps there, my lord. Kindly perusal last page, my lord, order Annexure 7, my lord. Page 49. Accused Biswajit Roy, Kartik Roy, Arjun Roy, so. are absent, which step file petition number so and so, so in
But we, unless we find out what was your role, anticipatory bail may not be granted. Unless we have to peruse the scan copy of the
Yes,
case
yes,
there. Heard Mr. H. Das, learned counsel for the. Also heard Mr. K. Parashar. In this case, the petitioner has approached this court seeking anticipatory bail in connection with PRC case number 1713/2023, wherein charge sheet has already been filed. Stop. Learned counsel for the petitioner submits that the case is presently pending before the court of
the judicial magistrate first class.
judicial magistrate first class, which is the committal court. And as section 302 of the Indian Penal Code is involved in this case, he apprehends that on his appearance, the petitioner may be remanded to custody. Stop. Let the scan copy of the case diary of Golokganj PS case number 579/2007 be called for from the committal court. Registry to issue requisition for the scan copy. Let this matter be listed on 18th of September.
Abhilash, my lord.
My lord, I'm sorry, my lord, 47, my lord, I am on impression, my lord, after motion you will call my, but let it be taken. my lord.
47.
47.
One call.
Non-appeals petition 99.
We'll call it. You wait for your turn. You please wait.
Item 12.
Yes.
May I please lordship? Lordship, here the petitioner is the husband lordship and respondent is the wife lordship. Their marriage took place in the year 2002 lordship. And the respondent has filed a divorce petition, that is his wife lordship, in the year 2022 in the month of January.
Which is the impugn order?
Yes, impugn order. Impugn order lordship can come from page 62 lordship. When they file a petition for pendant light of maintenance lordship. Page 62 and operative part is lordship. Page 66 lordship.
You are husband.
I have husband lordship. Page 66 operative part lordship, last paragraph. May I read lordship?
Yes.
In the result, the pair of the petitioner is partly allowed, there is petitioner here, there is wife lordship, partly allowed directing the husband of P. Milan Singh to pay rupees 6,000 per month as pendant light maintenance till disposal of the main suite, that is FC civil case number so and so. This order shall be effective from the date of filing of this miscase, that is with effect from 23/5/2023. The OP husband is hereby directed to clear up the area so far accrued by making payment of the monthly installment of rupees 10,000 per month, in addition to current maintenance of rupees 6,000, till the area is wholly paid up to the petitioner. Here, lordship, the petitioner earlier the petitioner was working as a Tiranga motor lordship. She has resigned from his post in the year 2024.
We are issuing notice.
Okay, lordship, kindly stay the order, lordship.
No.
Yeah, because he has no opportunity to give at present he is unemployed here, lordship. Okay,
No, not before. No.
He is just working as a motor company, Hero Motor.
No, not before appearance of let the respondent appear. Nothing will happen within 1 month. Heard, Mr. What is your name?
NH Laskar.
M.H. Laskar.
NH.
N.H. Laskar. This application under section 442/438 of BNSS has been filed
He is also working lady, lordship.
by the petitioner, namely Milan Singh, who has Milan Singh impugning the order dated 4/3/2025 passed by the learned Principal Judge Family Court Kachar in FC Civil Case number 15/23 arising out of FC Civil Case number earlier FC Civil Miss Case number 15/2023 arising out of FC Civil Case number 19/2022, whereby the petitioner was directed to pay a pendant-lite maintenance at the rate of 6,000 per month to the respondent, as well as area pendant-lite maintenance since the date of filing of the said Miss Case. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondents within 7 days from the date of this order, returnable on 24/9/20.
24/9. Lordship, at least
List according.
she may stand order. Okay.
After returnable date, we will consider. Not without hearing.
She's working.
Let her appear, in 1 month, nothing will happen.
Item 13.
I know.
My lord, this is against, my lord, the judgment passed by the Principal Judge Family Court on 5/7/2025, my lord, in FC criminal case number 138/21, whereby the petitioner has been directed to pay rupees 7,000 per month to the respondent from the date of filing of the case. My lord,
We are issuing notice.
my lord, on the same set of allegation, she has also filed a divorce case in which the learned, my lord, judge, kindly see, my lord. Same set of allegation, my lord, kindly see.
This is 125.
Yes, my lord. And she also filed a, my lord, she had also filed a, my lord, divorce case. But in that, on the same set of allegation and evidence, my lord. But on in that case, my lord, the learned judge, my lord, kindly see, my lord. Page, my lord, 30 of the petition. Same set of allegation, my lord, same set of evidence, my lord. Kindly see issue number 3 and 4.
No, what happened? What was?
This, my lord, he appointed the allegation which is filed against the my lord, the petitioner. May I read, my lord?
No, what is your submission?
My lord.
In divorce case, what or it is pending? Divorce case is pending or this?
Because it's not started on the ground that the cruelty and desertion which she
We are issuing.
not be established, my lord. And moreover, he is a jobless person. It is known to her family before marriage, my lord. And the petitioner is
After her appearance, heard Miss.
Jobless person.
No
it is known
interim.
to the family, my lord.
Heard Miss N.S. Thakuria, learned counsel for the petitioner. Also, this application under section 438/432 read with section 528 of BNSS has been filed by the petitioner, namely Uttam Kumar Goswami, impugning the judgment dated 5/7/2025 passed by learned Principal Judge Family Court, Kamrup in FC criminal case number 138/2021, whereby the petitioner was directed to pay a maintenance amount of rupees 7,000 per month to the respondent, who is the wife of the present petitioner. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by registered post with AD as well as by usual mode within 7 days from the date of this order. Returnable.
Stayed, my lord.
No, there is no urgency. You pay 7,000 to your wife, nothing will happen.
May I plead the lordships? My lord, the petitioner challenges the order of the payment of interim maintenance to his wife, my lord. The order dated 1/6/2024, my lord, which your lordship will find at page 55, my lord.
The interim maintenance in 125,
Yes, my lord.
it is still pending.
Yes, my lord.
What
It
is-
pending, my lord, my lord, let notice go, but my immediate prayer is that, my lord, by this impugn order, interim maintenance of rupees 10,000 has been granted to the wife, my lord.
What do you do?
I am, my lord, at the time of filing of this case and when I filed my assets, affidavit of assets and liabilities, at that point of time, I was not, prior to that, I was a medical representative, but subsequently my job was terminated and the time of the affidavit assets and the
Let the
liabilities.
notice go.
Notice go, and my limited prayer is that, my lord, the interim maintenance may be reduced to some extent because 10,000 has been ordered, my lord, and she is alone, my lord, and she is residing in village, my lord.
No interference now without hearing your
Because,
wife.
my lord, if your lordship sees her affidavit, my lord, assets of
No, let her appear. Let her place her own case. Her, which is the item number?
14, my lord.
Heard Mr. D.P. Bora, learned counsel for the petitioner. Also, stop. This application under section 528 of BNSS has been filed by the petitioner, Jamir Ali, impugning the order dated 1/6/2024 passed in FC's criminal case number 341/2022 by the learned Principal Judge Family Court Barpeta, whereby the petitioner was directed to pay an interim maintenance of rupees 10,000 per month to the respondent. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by registered post with AD as well as by usual mode within 7 days from the date of this order. Returnable after 3 weeks.
Obligation.
16.
May it please the Lord. My lord, this Quashing petition is filed by the mother-in-law, sister-in-law, and also the two persons who are also made party by the opposite party when he filed a petition before the court, magistrate court, my lord, under domestic violations case, my lord. My lord, as for the last order of this on the court, my lord, we have also brought on record by way of affidavit the latest petition whereby notice has been issued to the opposite party, that is present petitioners, my lord. My lord, may I draw your lordship attention to the applications he has filed before the magistrate, page 47, my lord. Page 47, annexure 3. Your lordship might have gotten.
Yes.
My lord, this is domestic DV case number so-and-so, 2024. Her name is Neha Sharma, wife of Tanvir Ahmed. That is present petitioner number 1, son, my lord. And their address is shown, care of Dilip Singh, house number 5, Munipuri Basti, Rajbari, Paltan Bhai. This is her address, my lord. And opposite party is myself, my lord, Salina Begum, and Masina Begum is the daughter of Saleh Begum, a divorcee daughter who is living with the mother, and two other persons, my lord. One is a tenant and another is a knife. My lord, kindly see page 48, my lord. The first line of the petitioner is a citizen of India and as such is entitled to all rights, protections, and privileges as granted by the Constitution of India and law framed thereon. Then, my lord, you will also kindly see that the petitioner has married with
On what ground you are seeking quashing?
my lord, we were seeking Quashing, my lord. It is absolutely a fabricated and brought up case. They got married. And the petitioner Neha Sharma got married with my only son, who in the year 2007. And she has taken my son and living in the mother-in-law's house, that too in a rented house. My son is taken away from her. And my son is a drug addict and also a drunkard. And they are quarreling among themselves, my lord. Sometimes my sons come to my house. I am a widow, my lord. I have only house rent, and there are 2-3 rented house. I am living on this, my lord. And sometimes comes and quarrels with the tenants and other thing. And she is staying in a different place along with her mother. In her petition itself, she has stated that the mother had only one son. After the death of the mother, she is permanently residing in Manipur, which is in the rented house. And my son also comes and stays with her in Manipur University. Whereas I am in Ulubari, my lord, sometimes my son comes and quarrels with the tenants to get money. And they have made my life a havoc, my lord. I am a widow or living with my daughter, only daughter, who is also driven away by her husband by way of divorce, and she is staying with me. Now, my kindly see that, my lord, she had admitted in this petition itself that her husband, that is my son, has filed a type suit claiming family property from me, my lord. This is also pending. The lordship kindly see Annexure 1, page 22.
What is your submission that the accusation, the allegations leveled are false?
Because, my lord, they are leading questions. She got married, they got married out of love affairs in the year 2007.
No, but she has alleged the torture by you.
she's not living with me, my lord.
No,
No
when
question
you
of
go
torture
to
comes.
their residence,
They are living separately. She does not come to my place. Even my son is also taken away by her. And he sometimes comes and quarrels being drug ready. They are living in her petition itself. She has admitted there are several complaints in the Porter Bazar police station.
no, in para 5 of the complaint,
Yes, ma'am.
page 49, whenever she and her husband comes to your house, you used to torture them. That is the allegation.
My lord, my son comes to my house and quarrels with my tenants. Have to get money, my lord. On this issue, I filed complaint to the police station. She also goes to police station. Son also goes to police station. Police is a family matter. Let them return, my lord. And son being overdranked, she is admitted in her petition, my lord. Then I was compelled to send him to the rehab center. This is a genuine case, my lord, because being overdrunk and drug addict, when the sons make the life havoc in the society, I had no alternative.
We are issuing notice. Mr. M.H. Rajbarguya, learned counsel for the petitioners. This application under section 528 of BNSS has been prayed for quashing of the proceeding of DV case number 127/2024, presently pending before the Court of Learned Judicial Magistrate First Class, Kamrup Metro. Let the notice be issued to the respondent. The petitioners shall take steps for issuance of notice upon the respondents within 7 days from the date of this order, returnable after 3 weeks.
I'm very happy because of if the lawsuit kindly pleases to stay till the returnable date, my lord. Otherwise, there will be pressure created on us.
When is the next date? When is the next date fixed?
My lord,
Next date.
next date, 9 of September. And madam, see the condition of the woman, my lord.
No,
Plus
you
60 years, very old.
you pray
And in fact, she
only after due service of the
It
notice.
will benefit for both the parties. He will come and make the matter will compromise. We want that my son should come in my house. He take the responsibility. He's fighting a title suit.
That may not be ground for stay. Let her appear, let the complainant appear. Or let the notices be duly served at least, then we will consider. We are at the fixed date. Let this matter be listed on 24/9.
Obliged.
Item 17. I'm sorry, Lordship.
Obliged, ma'am.
I'm sorry, item number 25, Lordship, bail application, Lordship, this CD has been adjourned, Lordship, only prayer made by the petitioner. On the last two occasions also, Lordship, they have adjourned it. Only thing, Lordship, we will be allowed to update the CD.
Item number
25.
25. What is the date gap?
17/9.
The case diary may be returned back to be called again after updation. Yes.
May please, Your Lordship. For the quashing petition, to file for quashing of the FIR of Rota PS case number 44 of 2025 and subsequent Chargesheet and the order of cognizance dated 19/5/2025.
What is the ground?
Lordship, the FIR was filed as a counterblast to the FIR filed by the petitioner. Lord. I'm just pointing it out, Lordship. What happened? On Lordship.
But Chargesheet has been filed.
Lordship, I have challenged both the FIR, Chargesheet and the order of cognizance. My Lord.
Order of cognizance on what ground?
Because there is the non-application of mine, the cognizance has been taken by the learned trial court. Lordship will kindly see on 11/4/2025.
Okay, we are issuing notice.
Lordship, the next date is fixed on 24/9, Lordship, before the learned trial court, 24/9. If possible,
Heard Mr.
P. Das, Lordship.
P. Das, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the applicant, by the petitioner, Devojit Rabha, alias Devojit Rabha, praying for quashing of the FIR as well as proceedings of, as well as the charge sheet dated, charge sheet number 26/2025 dated 30/4/2025, as well as setting aside of the order dated 19/5/2025 passed by learned Chief Judicial Magistrate Udalguri, whereby cognizance of offence under section 281/296/115 within bracket 2/351 within bracket 2 of BNS has been taken against the petitioner. On what ground you are challenging the quashing order?
Lordship, basically the FIR, which was filed by the Lordship, the informant, there is the counterblast to the FIR filed by me. My
That is-
FIR was on.
That is your plea.
Lordship.
But why the cognizance order has been challenged?
Lordship, because the cognizance, without going to the materials on record, Lordship, the cognizance has been taken by the learned trial court. That is my contention.
Where is the order?
Lordship will find it at page 37, Lordship, Annexure 4. Case record is received on transfer for disposal. The IO has submitted the charge sheet by under section so and so of BNS against the accused person, namely so and so. After perusal, I have found sufficient materials to proceed against the accused persons, namely Devojit Rabha under section so and so so and so.
Issue
Accordingly,
notice to respondents since learned additional public prosecutor has appeared for the respondent. No formal notice need to be issued to respondent number 1. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice upon the respondent. Upon the respondent by a registered post with AD as well as by usual mode within 3 days from the date of this order,
Lordship.
returnable after 3 weeks. Let also the scanned copy of the records of the trial court along with scanned copy of the case diary of Rauta PS case number 44/2025 be called for list accordingly.
Lordship, till returnable there, Lordship, further proceeding may kindly be stayed, because
No.
the case is fixed on 24/9.
You appear there or you seek adjournment on that day. Only after appearance of the respondent number 2.
Lordship, then kindly a date may be fixed, Lordship.
25th. Let this matter be listed on
25th.
25th of September.
Item 18. Obliged, Lordship.
May I please, your lordship? My lord, this is a 528 quashing petition, my lord. Praying for quashing of the FIR, the charge sheet and the PRC case that has been registered, your lordship. Lordship, may kindly take the FIR first, your lordship, which is a page number.
No, when charge sheet has been laid,
My lord,
there is a presumption that there are materials.
my lord, my lord,
So unless we peruse the
Record, my lord.
records,
my lord.
no interim can be granted.
Yes, my lord, my lord, kindly take the FIR for one moment, my lord.
FIR stage has gone.
My lord. But even in the charge sheet, my lord, the offense is not made out. Section 419 and 493 has been charged. But the
So
essence,
to appreciate that, we will require the case diary.
the lower court record, my lord.
Yes. Heard Mr.
A Khan.
A.
Khan.
A. Khan, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner, Shri Bimal Sinha. Yes. Praying for quashing of the FIR dated 8/8/2024, on the basis of which all women PS case number 42/2024 was registered. The petitioner has also prayed for quashing of the charge sheet number 38/2024 dated 31/8/2024, as well as setting aside of the order dated 21/5/2025 passed by learned judicial magistrate first class Kamrup Metro in PRC case number 1719/2025, whereby the cognizance of offense under section 419/493 of the Indian Penal Code was taken against the present petitioner. Issue notice, since learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to the said respondent. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice upon the said respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks.
My lord, the next date is fixed on 24/9. Can it be fixed before that, my lord?
Not how will you ensure service
Service
of
of
notice? So let it be after 4 weeks
My lord.
on a date to be fixed by this.
Obliged, my lord.
May I please, your lordship? Lordship, his quashing petition is filed to transfer to NBW order, my lord, issued against the petitioner, my lord. It was a 138 proceeding under NI Act, my lordship. The petitioner was appearing, my lordship, and was represented by her advocate, my lordship. But on annexure page 27, my lordship,
When is the date fixed?
next date, my lordship, on 16/9.
You appear on
My
16/9.
lordship.
We will stay. And after appearance, you pray for cancellation of the NBWA before the said court.
My lordship, if we please to do, yes, my lordship, that can be, yes, my lordship, but my lordship, if you look for a second page 27.
Why NBWA was required to be issued
My
against?
lordship, steps also been taken and it was fixed for evidence, my lordship. Those steps-
Why you defaulted?
My lordship, I have stated clearly, my lordship may kindly be pleased to peruse. My lordship, on that day, my lordship, I have lost my mobile phone. And my lordship, I could not contact my engaged counsel.
Okay.
And
On which date?
my lordship on,
5/3.
yes, my lordship, on 5/3/2020.
Mr. Parashar, let him appear.
My-
Heard Miss S.G. Barua, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, an additional public prosecutor. This application under section 528 of BNSS, read with article 227 of the Constitution of India, has been filed by the petitioner, namely Lukumoni Hajorika. You are a female,
My lordship.
namely Srimati Lukumoni Hajorika, alias Lukumoni Hajorika, impugning the, praying for setting aside of the order dated 19/6/2025,
My lordship,
5/3/2025, as well as 19/6/2025, passed in CR case number 3109/2019 by learned SDJM S with the /2 Kamrup Metro, whereby non-bailable warrant of arrest were issued against the petitioner. Learned counsel for the petitioner has submitted that the petitioner is facing a trial before the Court of Learned Subdivisional Judicial Magistrate S-Roman 2 in PRC case number. What is the PRC case number?
My lordship, it's CR case, my.
In
lordship,
CR case number
31.
3109/2019 under section 138 of the Negotiable Instrument Act. Learned counsel for the petitioner has submitted that the petitioner was regularly appearing before the trial court, and the trial was pending at the stage of
Evidence, my lordship.
evidence of the complainant side. Stop. However, she submits that on which date you
24
defaulted?
to 2025, I lost my mobile and thereafter couldn't contact my engaged counsel.
On 24/2/2025, the petitioner lost her mobile phone, and as a result, she could not contact her engaged counsel, and therefore she was not aware of the next date fix and defaulted in appearing before the trial court on 5/3/2025 and on subsequent dates. Learned counsel for the petitioner submits that the petitioner was appearing in the trial court in the said CR case and is willing to appear and cooperate in the trial. However, as non-bailable warrant of arrest, no, when is the next date?
On 16/9.
Learned counsel for the petitioner submits that the next date in CR case number 3109/2019 is fixed on 16/9/2025, and the petitioner is ready to appear, ready and willing to appear before the trial court on the said date and cooperate in the trial. Stop. However, she apprehends that as non-bailable warrant of arrest has been issued, hence, unless some protection is granted to the petitioner, it would be difficult for her to appear before the trial court on the said date. I have considered the submissions made by learned counsel for both sides and have gone through the records of the records available before me. Considering the grounds shown by the petitioner for her non-appearance on on 5th of March 2025 in CR case number 3109/2019 before the Court of Learned SDMS 2. And considering the fact that the petitioner is ready to appear before the trial court on the next date fixed, this criminal petition is disposed of with a direction to the petitioner to appear before the trial court in CR case number 3109/2019 on the next date fixed. That is on 16/9/2025 to facilitate her appearance before the trial court. The operation of non-bailable warrant of arrest issued against her by the trial court shall remain suspended till 16/9/2025. Stop. On her appearance before the trial court in pursuant to the direction of this court, the petitioner may seek appropriate relief from the trial court in the said case, if so advised. This criminal petition is accordingly disposed of.
And the honorable as per law, my lord, and the honorable.
They will all, it is presumed that they will.
Bless my lordship.
Please, your lordship. Lordship, this is a 520th application for quashing of FIR, Chargesheet, and order of cognizance dated 31/3/22.
What is your ground?
Lordship, it's completely based on co-accused statement, and cognizance has been taken without applying any judicial mind.
Heard, Mr. What is your name?
MS Hussain.
MS Hussain, learned counsel for the petitioner. Also heard Mr. KK Parashar, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner, namely Habib Badruzaman Khan, alias Habib B. Khan. Praying for quashing of the FIR, Chargesheet, and the order of the cognizance taken on 31/3/2022 in PRC case number 316/2022, pending before the Court of Learned Judicial Magistrate First Class Vijay. Stop. Call for the scanned copy of the trial court records as well as scanned copy of the connected case diary. The registry to issue requisition for the scanned copies. Also issue notice to respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 and 3, by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Place this matter after 4 weeks.
Finally, a date may be fixed.
Or after 4 weeks. It will go after vacation. After vacation, then the 15th of October.
Can it be before?
No, let it be after 4 weeks on a date to be fixed by registry.
Actually, on 15 then.
Okay, 15 October.
That's okay.
Timing item, I think 47.
My pleasure. My lord, it is a charge-sheeted case, my lord. Already, my lord, PW are examined, my lord. One is, my lord, informant, and another is
POXO matter.
POXO matter, my lord.
Heard, Mr.
My lord, he was arrested today, my lord, 84 days, my lord.
No, charge sheet has
My
been
lord, my
filed.
lord, my right part.
Heard Mr. A.
Not
Manna,
definitely given.
learned counsel for the petitioner. Also heard Mr. K. Parashar. Let the scanned copy of the trial court records. On what ground you are seeking bail?
My lord, bail already been rejected, my lord. My lord, since my lord, he is my lord about my lord 18 years, 17 years, 7 months, 19 days on the date of the our statement under section 164. Nowadays, my lord, 180.
Also call for scanned copy of the connected case diary. Stop. Issue notice to respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice upon respondent number 2 within 3 days from the date of this order, returnable on 22nd September.
Obliged, my
Item 22.
highly obliged.
Yes.
Legal lock.
NCB.
NCB.
We'll take after some time, let NCB come. You may inform Pisar Matim. You're also NCB.
Right.
Okay.
May it please your lordship. It's a charge sheeted case, my lord. Here the petitioner was arrested on my lord on 1/8/21, my lord. Page 23, my lord. And charges were framed, my lord, on 01/02/23, my lord. And citing, my lord, 12th number of witnesses, my lord. Till date, my lord, only 6 witnesses have been examined, my lord, to my information, my lord. And my ground before your lordship, my lord, section 50 notice.
Out of how many witnesses?
12.
Well, how many have been
6,
examined?
my lord. To my information, my lord. Yesterday, as I also checked, my lord, 6 witnesses have been examined. And the next date is, my lord, on 16/9/25.
Yes.
My ground, my lord, here section 50 notice and 50A notice were not served.
Where are not served or it does not contain the ground?
No, not served, my lord. My submission is not served. my lord.
What else?
That much, my lord, Vihan Kumar. Record number.
And prolong in how many?
Prolong, my lord, 01/08/21, my lord. Arrested.
So what is the time?
My lord, it will be
More than 3 years,
Yes.
4 years. More than 4 years.
4 years. Ruby Prakash.
Yes.
My lord, regarding their notice 50, I want to submit the arrest memo is there and all the facts in the arrest memo is there.
Where is the arrest memo?
Arrest memo, I have annexed, my lord, page
Page
23.
23. And their signature is also there.
No, have you furnished the copy of arrest memo to the,
Yes, ma'am.
Arrest memo, my lord, admitted, my
you
lord.
have received?
We have received. My signature is there, my lord.
So it contains ground of arrest.
My lord, one submission, my lord, if your lordship says, my lord, page 23, my lord. Last line, my lord. My lord, for contravention of provision of section 8C of the NDPS. my lord. If your lordship sees the 8C, my lord, there are, my lord, 12 or 13, my lord, categories are there, my lord. Who exports, who imports, who possesses, my lord. It is not specific, my lord.
So the accused person is the driver of the vehicle, my lord.
But the But the truck which you were driving, from that truck, this
Yes.
contraband was
contraband, yes.
recovered. So this is not very convincible.
My lord, prolonged incarceration, my lord. Out of 12,
Yeah.
my lord, 6 were examined.
Trial proceeding is going on, my lords, and the process has been already speeding up.
No, but 4 years is too much. Heard Mr. N.J. Datta, learned counsel for the petitioner. Also heard me. Where do you stay?
My lord,
Mr.
I've given my address, my lord.
Within Assam or
No,
outside?
my
of-
lord, no, my lord, no, my lord, Bihar, my lord.
This is the main fact.
So what is the
Take
assurance once you get bail?
Sure it is, but
stringent condition.
stringent condition. Too sure.
Also Miss P.S. Chakrabarti, learned counsel appearing for DRI. This application under section 483 of BNSS has been filed by the petitioner, namely Sahab Singh, alias Sahab Singh, who has been detained behind the bars since 1/8/2021, within bracket, for more than 4 years, bracket close, in connection with NDPS case number 27/2022 under section 20B2C/22C/29 of the NDPS Act, presently pending before the Court of Learning. Additional Sessions Judge, number 5, Kamrup Metro. The gist of accusation in this case is that on
31/07/21.
on 31 7 or 1
Seven.
7/2021, an information was received by the officials of Directorate of Revenue Intelligence at Guwahati that huge quantity of ganja is being transported in a Tata truck bearing registration number RJ14GB 8671 from Agartala to Guwahati. Accordingly, a team was constituted and the said truck was intercepted. During search of the said truck, aforementioned truck, two 269.75 kg of suspected ganja from 33 packets kept in 33 packages were recovered from the vehicle, of which the present petitioner was the driver. Stop. Learned counsel for the petitioner has submitted that the petitioner was not served any notice under section 50 or 50A of CRPC at the time of his arrest. Hence, there has been violation of his fundamental rights under Article 22(1) of the Constitution of India. He also submits that the petitioner has been languishing behind the bars since the date of arrest for last more than 4 years, and till date only 6 out of 12 listed prosecution witnesses have been examined. He submits that at this phase, there is unlikelihood of early culmination of the trial, and therefore he submits that the fundamental rights guaranteed to the petitioner under Article 21 of the Constitution of India has been violated in this case due to his prolonged incarceration. And on that ground, he is entitled to get bail in this case. On the other hand, learned counsel for DRI has submitted that at the time of the arrest of the petitioner, the arrest memo was prepared, mentioning therein the grounds of arrest of the petitioner in detail, and a copy of the same was served on the petitioner after obtaining his thumb impressions thereon. She therefore submits that there is no violation of the fundamental rights, no violation of the constitutional mandate as contained in Article 22(1) of the 22(1) of the Constitution of India. She also submits that already 6 witnesses have been examined in this case, and only 6 are remaining. And it would not take much time for examining the said witnesses and completion of the trial in this case. She also submits that the quantity of contraband seized in this case is of commercial quantity, and therefore the embargo of section 37 of the NDPS Act 1985 is applicable to this case. She therefore prays for rejecting the prayer for bail of the petitioner. I have considered the submissions made by learned counsel for both sides and have gone through the scanned copy of the trial court records. Quote paragraph number 17 from bail application number 3881/2023, dated 22/1/2024. Para 17. '18, 19, 20, 21, 22, 23, 24. In the instant case also, the petitioner has been detained behind the bars for more than 4 years, and only 6 prosecution witnesses have been examined. At this pace, it is unlikely that the trial would culminate soon. And in view of the facts and circumstances of this case, as well as considering the observations made by the apex court in the ruling cited herein before, this court is of considered opinion that in the instant case also, the facts and circumstances are such that the long incarceration of present petitioner has resulted in infringement of his fundamental right guaranteed to him under Article 21 of the Constitution of India. And as such, the fundamental rights and the said fundamental rights guaranteed to him has outweighed the embargo of section 37 of the NDPS Act in this case. And the petitioner is entitled to get bail on the ground of prolonged incarceration only. In view of above, Code Para 26, 1 lakh with 2 sureties of like amount. One of the surety should be the resident of state of Assam with certain conditions. This bail application is accordingly disposed of.
I'm obliged, deeply obliged.
24.
May it please your lordship. Here, my petitioner was on interim, my lord.
Interim.
Interim, my lord.
But this is a regular bail. application.
Lordship, on regular bail, Lordship has granted interim, my lord.
Why?
My lord, Lordship order, my lord.
No, why it was granted?
So, my lord, the Lordship may kindly turn to the FIR, your Lordship.
No, why interim was granted? What was the reasoning?
But the reasoning, my lord, because, my lord, the allegation is that, my lord, that 4 persons, my lord, they went to the house of the petitioner at 1:20 AM in the night, my lord. Then, my lord, the petitioner, my lord, fired rounds with a licensed gun, my lord. Then, my lord, they were continuously banging. Then the petitioner and those persons, they went to the police station. Both the petitioner was also arrested, and, my lord, the persons who came there were also arrested, my lord. There were a pre case and a cross case, my lord. Those persons were also released on bail, and, my lord, by this honorable court, and, my lord, the petitioner was granted interim protection. Because, my lord,
It was granted primarily also because they have filed one FIR also, Lordship, that was filed prior to the one.
This pending investigation,
Yes, Lordship, CD has been received.
whether his statement has been recorded.
Yes.
What is your submission?
Lordship, for that, Lordship, if Lordship kindly goes to the situation that happened, Lordship, the informant, Lordship, around 3 or 4 people went to their house, Lordship, in search of his elder brother.
Whose elder brother?
my elder brother,
His elder
at
brother.
1:20 AM in the night.
In the night, Lordship. And then, Lordship, there was some ruckus, some foul language was used. Thereafter, he came out of the house with a gun and he fired 1 round in the air, Lordship. Thereafter, they escaped, Lordship. They went to the police station. He followed them there. And there, Lordship, the petitioner was arrested, Lordship. So that is the situation.
For showing gun.
Yes.
Okay.
So that is the situation, Lordship.
Yes, you are opposing. Why?
Because Lordship, this is not the case that he has followed them to the police station with bare hands. He was
No,
using his gun.
what is your ground for?
Yes, Lordship. Now, Lordship. So, Lordship may kindly peruse their petition page number 26, while rejecting their bill application. It was, the ground was shown therein. May I read it? Also, page number 26, last paragraph.
What is 26?
I have perused the grounds of arrest enumerated in the
Yes,
page number 26, last paragraph.
yes.
I have perused the grounds of arrest enumerated in the forwarding report. The brief facts of the case are the accused fired aiming to the husband of the informant along with the 2 other persons who were with the husband of the informant in order to cause death to them on 19/7/2025 at 1:20 AM. But during the fire, did not hurt them and they immediately left the place and went to the Misa outpost. Thereafter, the accused again came to the Misa outpost with his gun and threatened to cause death to them. The IO submitted the accused is involved in the case and he is the FIR name accused. During the investigation, sufficient evidence has been found against the accused. In Samuguri PS number 19-159/25 lodged by the accused, he stated that he fired on the accused of that case. During investigation, 1 gun license number this was seized from his house with empty case and muzzle loaded ammunition, and the accused is not the license holder of the same. Another gun in the name of the accused has been seized on being produced by the brother of the accused. There are videography and photograph evidence against the accused, and the arrest of the accused person is necessary for the purpose of the investigation. The arrest of the accused is necessary to ensure presence and prevent him from causing disappearance of the evidence. Now, Lordship may again peruse the forwarding, where page number 14, point number 6. Page number 14, point number 5, 6, 7. Point number 6 states that UBBL gun, wed number this, license number this is in the name of the accused Biju Samaria, and has been seized on being produced by his brother Ramesh Samaria and used to threaten him, kill him, the victim persons on the public road. Now, Lordship, there under another point number 5, there is 2 guns that has been seized. One he has fired in his house, and another he has came up to the police station with loaded gun in front of the gathering public he used both. If he has a license for one, he doesn't have the license for the other one. He is using both the guns.
But both the guns were seized.
Both the guns were seized, but the lordship, he has come with a loaded gun in that particular police station. That means he is a powerful person and fearless. Sorry. And he has come to the police station. If he can come, he can also threaten the persons, the petitioner hearing and the other persons again and again. And now he can also, he may, investigation process may be hampered if he is released on bail. And it is wrong precedent.
No, he is already released on bail.
Yes,
After his release,
he has
whether,
got the interim, your lordship.
no, after his release, whether he has misused his liberty, whether he has threatened you.
There has been subsequent threatening has been going on between both the parties. They have been saying that you take up the FIR, then only we will take our FIR from you. Such kind
You
of
have filed any objection, written objection?
In that regards, we have not filed any objection. We are objecting to the bail application right there, right now.
What is there in the case diary?
From the investigation point of view, lordship, the seized weapon has been sent for everything. And the report is not.
So for the purpose of investigation, this is not, his custody is not required. But if he is threatening you,
Yes, Lord.
then you
He
have
has
to,
threatened that to take away the case from him, then only he will take away the case from us.
no, then that accusation has to be specific.
Now we
It
will
cannot
give
be
an
oral.
opportunity to give a in written objection for this bail. We would not file a written objection. He may be given an opportunity for 1 week time to file a written objection.
My lord, he is on interim, my lord. He has never misused his fellow jump bail, my lord.
No, let them file bail.
My lordship may kindly see that 1:20 AM, 4 persons went to the house of the.
Yes, why you went
one
at
to the petitioner,
1:20
my
AM?
lord. Now they were continuously banging the door at the night. What a helpless person will do? He will obviously come out with his gun, my lord. And when he has not yet shot in the case that it clearly reveals. So my
Heard Mr.
Lordship, the real fact is that the one of the accused person in that case had his marriage, and so he asked for the 15 lakhs rupees that was being borrowed by the Biju Samaria. Then they asked him to call him at night only at 1 AM. They were busy with their marriage, and they himself have planned the same. They came to the night at the place and they shoot it.
Heard Mr. S.M. Abdullah P. Learned counsel for the petitioner. Also heard Mr. B. Sharma, Learned additional public prosecutor, as well as Mr.
Yes, Ahmed.
A.
Yes, Ahmed.
S. Ahmed, Learned counsel appearing for the informant.
For the informant.
The informant. It appears from record that the petitioner was granted interim bail by this court on 25/7/2025. Stop. Learned counsel for the petitioner has submitted that petitioner has cooperated in the investigation and his statement has been recorded by the investigating officer. He also submits that the petitioner, while on bail, has never misused his liberty, and he is ready to continue to cooperate in the investigation. And therefore, he prays for making the interim bail absolute. On the other hand, Learned additional public prosecutor has produced the case diary of Samaguri PS case number 160/2025 under section Samaguri PS 160/2025 and has submitted that the petitioner has cooperated in the investigation and his statement has already been recorded. He also submits that the case is now pending for receipt of the FSL report in respect of the arms and ammunitions sent for the FSL examination. On the other hand, When have you filed your wakalatnama in this case?
Worship, on the last date that was listed, Your Worship.
14/8.
Yes.
So you have not filed any written objection.
We could not file
But
any
till
written
now, they have
because
not-
the
no
party
complaint
could
in
not
the police
come to Guwahati. That is
No,
the
no
reason why-
FIR, they have not lost, nothing FIR, no FIR. Now, my lord,
Learned counsel for the informant has submitted that the petitioner, after getting bail, getting interim bail, has threatened. When have they threatened?
It has happened, it has been happening continuously since he's getting bail.
Continuously, there must be some dates.
Exact dates I cannot provide you also because it has been informed to me that this has been happening frequently.
Has been frequently threatening the petitioner and threatening the informant. However, he has failed to mention any specific date or time when such threatening was done. No FIR has been lodged.
No FIR has been lodged in this regard also.
He also submits that the petitioner, the informant, has not lodged any FIR against the petitioner regarding the threat given by him to the informant while the petitioner was on interim bail. Stop. I have considered the submissions made by learned counsel for the petition, both sides, and have gone through the case diary of Samaguru PS case number 160/2025. It appears from record that there is nothing in the case diary to indicate that the petitioner has abused his liberty while he was on interim bail. It also appears that the investigation has fairly progressed, and for the purpose of investigation, custodial interrogation of the petitioner is not necessary. As regards the submissions of learned counsel for the informant regarding threat given by the petitioner, it appears that no written objection has been filed by the petitioner, filed by the informant. Neither any specific dates of alleged threat has been mentioned by the learned counsel for the petitioner, nor any FIR has been filed in this regard. Under such circumstances, this court is of considered opinion that if the interim bail is made absolute with certain conditions which may take care of the concerns shown by learned counsel for the informant regarding abuse of liberty by the petitioner, his custodial detention may not be necessary. Stop. In view of above, the interim bail granted to the petitioner by order dated 25/7/2025 is hereby made absolute with condition number 1 and 2 attached to the said order remaining intact. It is hereby made clear that any violation of the above two conditions may be a good ground for cancellation of bail granted to the petitioner. With above observation, this bail application is disposed of. Send back the case.
oblige you, Lord.
Item 22.
May I please allow?
May I
Here
please,
in the-
Lordship, we will not file our objection, Lordship. Actually, objection not received, Lordship. Kindly sorted may be given if objection not received, we are submit our oral objection, Lordship.
How
Last
much-
occasion,
What is the ground? On what ground you are seeking, Mr. Khan?
here one ground is prolonged incarceration is there. And thereafter, you are also not furnishing the ground of arrest.
When will you file objection? What is the contraband? How much is the contraband? How?
520 kg of ganja, Lordship.
200?
297 kg ganja.
When will you file objection? You choose a date.
The name of filing of objection, your lordship, in earlier occasions,
10th
also
of
they have time.
September, Lordship. If we are not file our objection last date, Lordship, we are.
If they fail to file, we'll proceed with the hearing on the next day. Heard Ms. N. Kakoti, learned counsel for the NCB. No, heard Mr. M. Khan, Mr. M. Khan, learned counsel for the petitioner. Also heard Ms. N. Kakoti, learned counsel for NCB, who seeks one more opportunity to file written objection in this case. Considering the submission, one last chance is granted to the petitioner and to the NCB to file written objection. Let this case be listed again on 15th of September.
Highly obliged, Lordship.
May it please your lordship. Lordship, this is a regular bail application, lordship, charge sheeted case, lordship. 136 days in jail custody, lordship.
How many?
Here, FIR
How many days?
136 days today, lordship. Charge sheet was submitted on 31st/5 and this petitioner was arrested on 22/4/2025. lordship. Now, FIR in page 16, lordship. As per FIR, lordship, the police receive, the informant received an information that this petitioner, lordship, but lordship peddler projected him as a peddler, lordship, and recovered, lordship, 10,000 Uva tablet from this petitioner, lordship. Accordingly, lordship, this petitioner was arrested and forwarded on 22/4/2025. Forwarding report, lordship, will find on page 18, lordship.
Yes, what is your ground?
Ground, lordship, here, lordship, 47 and 48 notice. This petitioner, lordship, can you see is an illiterate person, lordship, putting his thumb impression, page 27, lordship. The ground of arrest mentioned in this, not in the language which he could understand, lordship. It is given in English, lordship. And the person, and it is not stated, lordship, it was read over to him, lordship. This is the ground, lordship. On that ground, this petitioner has moved before the court below, lordship. His bail prayer was rejected. That is on page 29, lordship.
Where is the 47 notice?
47 notice, lordship, you will find on page 25, lordship. It is all in English, lordship. In this regard, lordship, I am relying on that, lordship, Dhyan Kumar, lordship, para 13, lordship. May I place that?
Yeah.
Para 13 and 21, lordship.
What is the requirement?
It should be in the language, lordship, which he could understand, lordship.
Or it may be read over to him in that
That was
language.
not, because that they have, IO has not submitted with the affidavit, lordship. He has read about it to the petitioner, lordship, accused, lordship. That is not supported by an affidavit, lordship. And same was lordship in conclusion, para 21, lordship. B. At flag mark there, lordship.
Whether trial court records have come.
Yes, lordship.
Yes. This is your ground.
Yes, lordship.
Yes, Mr. Sharma.
Lordship, from the scan copy, I have flag mark lordship. Lordship will find one order dated 20/4/25. Dated 20/4/25. I have flag mark lordship.
Yes.
Yes, lordship will see there is a paragraph where the magistrate has recorded lordship further. The accused and learned LADC have stated that the accused and his family members are aware of his arrest and grounds of arrest have been properly communicated by police person.
Yes, you cannot take contradictory.
Because the language, lordship, what language it was, lordship? What language it is revealed, lord?
No. When you have stated before magistrate that it has been properly communicated to you.
Lordship, the kindly, the 48 notice, lordship.
From the order.
48 notice, lordship will show, lordship. Is it in regional language, lordship? Both the person are illiterate, lordship. They put their thumb impression, lordship, in the notice as well as the lordship 47 and 48 notice, lordship.
Lordship,
How she could understand, lordship?
This has been recorded by the magistrate, lordship. The accused and learned LADC have stated that the accused and his family members are aware of his arrest and grounds of arrest.
That is not, lordship, 48, lordship. Only because of Supreme Court said it should be in the language, lordship. What she could understand or he could understand.
No, but once you have stated before police that, well, before the magistrate.
Before lordship.
Before the magistrate, you have stated that you have understood. And you are aware about the grounds of
Lordship,
arrest.
before arrest, lordship, before producing before the magistrate, lordship, 47 and 48 notice was issued, lordship.
Yes.
That is,
and therefore,
that is not their, lordship.
Therefore, after your production, you have confirmed that you have understood.
That is their projection, lordship.
Not there. That is the order of the magistrate, which you have not challenged.
Because lordship is a, we are coming for lordship bail. Because of that, lordship, we have approached this court, lordship.
So there are two versions before this court. One is saying that this is not communicated in the language. And one version you have stated before the magistrate that you are aware about the grounds of arrest.
That is
why have they stated before the landed magistrate? Why have they stated it? That is the question. They can state, submit anything, lordship, but why? And lordship, this plea was also taken before the concerned lower court, lordship. That has also has been rejected.
Where is that rejection?
Letter I have annexed, lordship, 29. Sorry.
Lordship will find it in the petition. They have annexed it, page 28. It starts from page 28. Relevant portion, lordship will find it page 29. But
what was the reason given by the?
If kindly, lordship, allows me to read page 28, second paragraph, just to
yes,
get a basic facts, lordship. The factual matrix of the case is that the complainant so and so lodged an FIR with the OC so-and-so, inter alia that on 21/4/25, a secret information was received to the effect that one suspected drug peddler got apprehended by local people at 16th number Basti near Salgana River on RCC beach. On receiving such information, the complainant along with his team immediately rushed to the PO and found the apprehended accused person, namely Selimuddin. Accordingly, in presence of independent witness, the body of the accused was searched, and during search, police recovered so-and-so, so-and-so, so-and-so. Next paragraph, Lordship will find. Last paragraph, Lordship will see. Heard both sides. Page 29. Heard both sides. Perusal of the case record shows that the suspected Yaba tablets were recovered from the possession of the accused petitioner. Further, perusal of the notice under 47 given to the accused at the time of arrest shows that he was informed sufficiently about the grounds of his arrest. Although the learned defense counsel has taken the plea that the accused, being an illiterate fellow, had put his thumb impression in the notice without comprehending its meaning, but in my reasonable opinion, it is not a plausible plea that the grounds of arrest was not sufficiently communicated to the accused, given the fact that the notice under 47 BNSS contained the ground, and moreover, the suspected Yaba tablets were seized from his possession.
Okay. Heard Mr. B. Chaudhary, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Selimuddin, who has been detained behind the bars for since 22/4/2025, within bracket for last 136 days in connection with the NDPS case number 46/25, corresponding to Dholai PS case number 63/2025 under section 22C/29 of the NDPS Act 1985, pending before the Court of Learned Special Judge Kachar. Stop. The gist of accusation in this case is that one Gunjan Phukon, SI of police of Dholai police station, lodged an FIR before the officer in charge of Dholai police station, inter alia, alleging that on 21/4/2025, an information was received through reliable sources to the effect that one suspected drug peddler has been apprehended by local people at 16th number Basti near Shalganga River on RCC village, on RCC bridge. Stop. On receipt of the said information, the police team rushed to the said location and found the present petitioner being apprehended by local public. Now, it is also alleged in the FIR that on search of the body of the present petitioner, 9,999 numbers of suspected Yaba tablets were recovered therefrom. Learned counsel for the petitioner has submitted that the petitioner is praying for bail, in this case mainly on the ground of violation of his fundamental rights guaranteed to him under Article 22(1) of the Constitution of India, inasmuch as though the notice under section 47 of the BNSS were served on him. However, same was in English language, and petitioner is unaware about, petitioner being an illiterate is not familiar with the English language. He submits that in the case of Vihan Kumar, his state of Haryana reported in 2025 5 SCC 799. The apex court has, while laying down the guidelines to be followed while arresting a person, has observed that the information regarding grounds of arrest must be provided to the arrested person. Effectively in the language which he understands. He submits that the mode and method of communication must be such that the object of constitutional safeguard is achieved. He, however, submits that in the instant case, the same was not done. And apparently the petitioner who has put his thumb impression on the said notice is an illiterate person. And therefore there is violation of the constitutional mandate as well as guidelines laid down by the apex court in the case of Vihan Kumar versus State of Haryana stuff. On the other hand, learned additional public prosecutor has opposed the grant of bail to the petitioner on the ground that the petitioner as well as his engaged state defense counsel have stated before the magistrate when they have stated
In page 29, second paragraph.
stated before magistrate that no, this is the bail application.
Order there is 22/4/25.
Stated before the magistrate when the present petitioner was produced before the said magistrate within bracket additional chief judicial magistrate Kachar on 22/4/2025 after his arrest, that the petitioner and his family members are aware of the arrest as well as ground of arrest have been properly communicated by the police personnel. Stop. He submits that the petitioner once stated before the magistrate on his production that the grounds of arrest were communicated as well as were made known to him by the police personnel. Now he cannot take the plea that since it is in English language, the grounds of arrest were not properly communicated. He further submits that since the quantity of contraband seized in this case is of commercial quantity, the embargo of section 37 of the NDPS Act is applicable to this case. He therefore prays for dismissing the bail application. I have considered the submissions made by learned counsel for both sides. I have to think it over. I will pass orders in chamber.
Obliged.
Whether scan copy of the case diary is there, records as well as case diary.
Yes, yes.
Okay, I will go through.
Obliged.
Item 27, 28, and 29.
Chargesheet has been submitted.
Chargesheet has been submitted.
But in this case, my lord, when the arrested, my lord, the ground of arrest was not properly given in the arrest memo, my lord, so that is 47.
Plead before the trial court. Not. Heard Mr. Ainuddin. You are appearing in all the cases.
Yes, my lord, on item 27.
Heard Mr. Ainuddin. Item number 27. Also heard Mr. B. Sharma, learned counsel for the learned additional public prosecutor, who submits that though the case diary was called for, however, charge sheet has been laid in this case, bearing charge sheet number
176/25 dated 30/08/25.
In view of the submission of the charge sheet in this case, this bail application is hereby disposed of with an observation that the petitioner may approach the trial court and may pray for regular bail before the said court if so advised. Same order for 28, 29. Counsel's name is H.A. Ahmed.
Item 30.
Please, your lordship. Regular bill application, NDPS commercial quantity. My ground is, my lord, non-compliance of section 48.
48.
Even in the 47 notice, grounds are not there, but it's there in the arrest memo, my lord. Your lordship will kindly come to page 37.
Whether copy of arrest memo is furnished to the accused.
Yes, yes. That was my another line of submission, my lord, because the arrest memo which is prepared in terms of section 36 of the BNSS, it is to be submitted before the court, and
It is to the part of the record.
And law only mandates that it has to be signed by the accused or a family member or relative of the accused. It does not mandate that it has to be given to the accused.
Is therefore requirement of
Therefore, requirement
47.
of 47.
47 is there.
But even otherwise, my lord, since it is there in the arrest memo, so that line of argument may be raised to the prosecution. But 48, my lord, is conspicuously missing. Your lordship will notice in page 39, they have sent a WT message to the concerned police station where my family members reside, only mentioning that I have been arrested, that we have been arrested, without giving any reason.
Page number?
Page number 39 for petitioner number 1, my lord, and page 42 for petitioner number 2.
WT message to
The officer in charge of the police station where my family members reside. First of all, whether this was served on us, even if it is served, it does not contain the grounds of arrest. Only mentions my arrest.
yes. This is only your
Yes, ma'am. Only that.
Your lordship will kindly see the order dated 11/1/24. It is not in the scan copy. Okay.
Where have you flag mark?
It's scan copy.
Scan copy. Order dated
11/1/25.
Yes.
There also will see one of the paragraphs, it is written, on being asked, the accused persons have stated that they have no physical injury and also stated that their family members can engage counsel on their own.
Yes.
So, Lordship, in a way, Lordship, family members can engage counsel on their own. So, Lordship, the purpose that is intended, Lordship, that seems to be served. Now, Lordship, coming to the judgment in the Darshan case, Lordship.
Darshan's.
Yes, Darshan's case, Lordship, it has been held, Lordship, that prejudice has to be shown on the part of the accused for non-compliance of section 48 or 47, Lordship, as the case may be. Here, Lordship, 47 is complied, Lordship, and they are only on 48.
But Darshan's case has been.
Exactly. In that judgment, I would like to refer to judgment passed by the division bench, Lordship.
I have a copy.
Yes.
Darshan's case is there.
No, I'm submitting the division bench judgment. Lordship, kindly come to paragraph 16.
Nia versus.
Yes. This is the division bench judgment which is shown, Lordship, in that Bihan will prevail over Darshan
Darshan.
case. Yes. So, Lordship, I am referring to paragraph 16, Lordship.
Yes.
Lordship will kindly peruse. Keeping in view the decision of the Supreme Court in the case of State of Karnataka versus Darshan, etc., we are of the view that non-furnishing of the grounds of arrest in writing to the family relatives of the arrested persons immediately cannot be said to be illegal or violative of Article 22(1) of the Constitution of India and Section 47 of the BNSS. So this is the observation of the division bench in regards to 48, Lordship. I'm stressing on, Lordship, in view of the decision of the Supreme Court in the case of Darshan, etc., we are of the view that non-furnishing of the grounds of arrest in writing to the family relatives of the arrested persons, that is 48, cannot be said to be illegal or violative of Article 22(1) of the Constitution of India and Section 47 of the BNSS. The point is, Lordship, immediately. In the present case, Lordship, in the division bench case, Lordship, there was a delay of around 18 days. And that was held to be violative, Lordship.
But at least there was the grounds were communicated
Yes.
after 18.
Yes.
But in this case, you have not at all communicated.
48.
48.
Yes. But, Lordship, in the Darshan case, that was shown, Lordship, that if prejudice can be shown, only then there is a case, Lordship. That is the specific finding of
No,
Darshan.
but Bihan Kumar says that if you have not stated grounds,
Lordship.
Prabir Purkasta, Bansal and Bihan Kumar,
Lordship.
that if you have not mentioned the grounds in writing,
Yes.
that in itself is violative.
But, Lordship, the Darshan case against, Lordship, states another thing, Lordship. The
So
prejudice
Darshan
has to-
case is not applicable
in view of this judgment,
in view of
division bench judgment.
division
And
bench.
division bench has, Lordship, observed in paragraph 16, I have stated, Lordship, that immediately if the grounds of arrest are not communicated in a 48 notice, that
No,
cannot be
but
said to
suppose
violate.
it has no, this court can observe that in view of the, in view of that MSCT cases,
Yes. Yes, I'm a national insurance company. And I see, yes, I understand, Lordship.
what is the citation?
It is, Lordship, 1716 SCC 650.
Paragraph 15.
2017, volume 16 SCC 680. The
Yeah.
earlier decision has to be followed.
Yes.
Lordship, yes, I understand that, Lordship.
Then also it is not.
But Lordship will kindly go by the division bench observation, Lordship.
No, division bench observation is,
Bihan Kumar.
even if your argument is agreed,
Yes.
it is in that it is only in respect of not immediately giving the,
Yes, if not immediately given, but if they are informed and they have sufficient knowledge, and as I have shown the order, Lordship, they were sufficiently informed, Lordship. So the prejudice has to be shown by them, Lordship. What prejudice has been caused, Lordship, to them?
no, you mean to say that if there is no prejudice
Yes,
and if there is no compliance of 2021, there is no communication of grounds of arrest in writing,
yes.
then
And not then, Lordship, and if they are represented, Lordship, and they are aware of it from the records, Lordship. Just because there is no grounds where no, the family members were not informed, Lordship, that cannot be said to be violated. In the instance case, 47 notice contains the ground. Only regarding the family members, the information is not immediate or maybe not, they were not informed in writing, Lordship.
okay. You want to respond?
The order which my learned friend has read out, the order only says that my family members can engage a counsel.
Ability.
That only shows my competence and ability of my family members to engage a counsel. It does not in any way show that they were informed of the grounds of arrest. Now, your lordship will also kindly come to the notices, my lord. 39. That is, my lord, this notice was issued on the 11th of January of 2025.
Page.
Page 39, my lord.
Yes.
This was, I was arrested on 10th. On 11th, a WP message is sent to the jurisdictional police station, only saying that I have been arrested. So now when the division bench judgment paragraph 16 is read, my lord, paragraph 16 only says that if there is no immediate communication, the condition, the requirement of communication of grounds of arrest in writing remains. The only thing which has been said is that if it is not immediate,
it has to be within reasonable
it
time.
has to be within reasonable time. But in this case, my lord, there is nothing on record to show that grounds of arrest in writing were communicated to me. So even if all the judgments are read, my lord, together, the requirement of communicating the grounds of arrest in writing, which emanates from Vihan Kumar, that is there. What Darshan brought out was a prejudice-oriented test. The division bench of this Honorable High Court says that no, because of the NIC case, Vihan Kumar will prevail. A certain relaxation is given to the extent that if it is not immediately given, but if it's given in a reasonable point of time, it will serve the purpose. Yes. But it does not in any way say that there is absolute non-communication. Non-communication has not been validated, madam. So that is my humble submission.
Yes. Heard Mr. S. Nawaz, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Sapan Kumar Tiwari, petitioners namely Sapan Kumar Tiwari and Shiv Pratap Singh Yadav, who are detained behind the bars since 10/1/2025. How long you are behind the
208 days, madam.
Within bracket for last 208 days in connection with NDPS case number 43/2025 under section 18B, 18 within bracket small b /22C/29 of the NDPS Act 1985, pending before the Court of London, Special Judge Defoe. The gist of accusation in this case is that on 10/1/2025, one Mintu Soikya lodged an FIR before the officer in charge of which police station?
Delhi police station.
Delhi police station, inter alia, stating that on that day at around 11:30 AM, while conducting Naka checking duty, a vehicle bearing registration number AS 05H 9299 was intercepted, and during search of the said vehicle, 9.110 kg of opium and 1.03 kg, 030 kg of heroin, suspected heroin was recovered from the said vehicle. Chargesheet has been laid.
Charges have been thrown.
Stop. After completion of the investigation. No, before that, the petitioners, both the petitioners were found inside the said vehicle. Stop. After completion of the investigation, charge sheet was laid against both the above named petitioners under section 18 within bracket small b /21C/25/29 of the NDPS. Learned counsel for the petitioner has submitted that the petitioner is seeking bail. Petitioners are seeking bail in this case mainly on the ground of non-compliance of section 48 of the NDPS Act.
BNSS.
Sorry, 48 of the BNSS, as well as violation of the guidelines issued by the Apex Court in the case of Vihan Kumar versus State of Haryana and another reported in
2025 SCC online SC 269.
2025 SCC 5 SCC 799, wherein it was observed that the requirement of communicating the grounds of arrest in writing is not only to the arrested person, but also to the friends, relatives, or such other person as may be disclosed or nominated by the arrested person, so as to make the mandate of Article 22 within bracket 1 of the Constitution of India meaningful and effective, failing which such arrest may be rendered illegal. Learned counsel for the petitioner has submitted that in the instant case, the arresting authority had issued a WT message to the officer in charge of Balidi police station in Bokaro district of Jharkhand, in the state of Jharkhand, in respect of petitioner number 1, as well as another WT message to the officer in charge of Bihia police station in the district of Bhojpur in the state of Bihar in respect of petitioner number 2. Learned counsel for the petitioner submits that in both the WT messages were addressed to the officer in charge of the aforesaid police stations, and there is nothing on record to show that, in fact, in pursuant to the said WT message, the family members, friends, or nominated persons of the petitioners were communicated about the grounds of arrest of the petitioners. He further submits that the perusal of the said WT message would reveal that it is only an intimation regarding the arrest of the petitioners, without mentioning in the said WT message anything about the grounds for which the petitioners have been arrested. And therefore he submits that that there is a violation of the directions of the apex court in the case of, issued in the case of Vihan Kumar versus State of Haryana within bracket Supra in this case. And consequently, the fundamental rights of the petitioners guaranteed to them under Article 22 within bracket 1 of the Constitution of India have been violated in this case. On the other hand, learned additional public prosecutor submits that when the petitioners were produced before the magistrate after their arrest on
11/1/25.
on 11/1/35. Produced before the magistrate, produced before the subdivisional judicial magistrate within bracket M Bokajan on 11/1/35. The petitioners have intimated the learned magistrate that their family members can engage counsel on their own, which according to learned additional public prosecutor is indicative of the fact that the family members of the petitioners were aware about the grounds for which the petitioners, on which the petitioners were arrested. He further submits that as the petitioners have themselves stated before the magistrate that their family members will can engage counsel of their own. And as in the arrest memo prepared after the arrest of the present petitioners, grounds of arrest are mentioned in detail and the thumb impression or signatures and the signatures of the petitioners were also obtained therein. There it shows that the petitioners were aware about the grounds of arrest and they are not prejudiced in any manner. He further submits that in view of the judgment of the apex court in the case of State of Karnataka versus Darshan's case, State of Karnataka versus Shri Darshan reported in what is the citation?
So I have the criminal number, criminal appeal number.
It is reported
Yes, my lord, it is reported.
within bracket Dibo.
My
Criminal
lord, it's
appeal
2025 SCC online,
reported in 2025 SCC online
SC 1702.
SC 170. The apex court has held that mere non-furnishing, what has been held?
Paragraph 20, Lordship.
Mere paragraph
20
of the
20.1.5.
Yes.
where is that judgment?
Lord, I have only,
Darshan itself.
Darshan you have furnished.
I have only the relevant, printed only the relevant part, my lord.
Show me. Include at the printout practical. 20 point.
1.5.
No, but it itself says while the 50 is mandatory. If 50 is mandatory,
Only thing it is brought in is that, my lord, there must be
Kill-
demonstrable.
kill-
It is shown.
held that while section 50 CRPC is section 50 CRPC, which within bracket which corresponds to section 47 of BNSS bracket close is mandatory. The consistent judicial approach has been to adopt a prejudice-oriented test when examining the alleged procedural lapse. The mere absence of written grounds of arrest does not ipso facto render arrest illegal unless it results in demonstrable prejudice or denial of fair opportunity to defend.
Also, Lordship, 20.1.3, Lordship, clarified that substantial compliance with this requirement is sufficient unless demonstrable prejudice.
Learned counsel, learned additional public prosecutor also submits that. In the aforesaid case, the apex court also observed that the judicial precedents have clarified that substantial compliance with the requirement, with the constitutional and statutory requirement is sufficient unless demonstrable prejudice is shown. He also submits that the division bench of this court, while holding that in view of the judgment of division bench of this court in the case of National Investigating Agency versus Hang Min Len Mate alias Lelin Mate MATE within bracket criminal appeal order dated 21/8/2025 in criminal appeal number 234/2025 has held that in view of the judgment of the Constitution Bench of the Apex Court in the case of National Insurance Company Limited versus Pranay Sethi reported in 2017-16 SCC 680. And in view of the contrary observations made by the Apex Court in the case of State of Karnataka versus Shri Darshan ETC within bracket Supra vis-a-vis the observation made in the case of Vihan Kumar versus State of Haryana Supra regarding the requirement of furnishing grounds of arrest in writing. The division bench held that the decision of the Apex Court in the case of Vihan Kumar would be applicable as precedent. Learned additional public prosecutor submits that the said observation is only with regard to failure in compliance of failure to comply with the requirement of furnishing grounds of arrest immediately after the arrest is made and not otherwise. He submits that the division bench of this court has not made any observation regarding the observation of the apex court in Sai Darshan's case, in Sri Darshan's case, within bracket Supra, that mere absence of written ground does not ipso facto render the arrest illegal unless it results in demonstrable prejudice or denial of fair opportunity to defend. Stop. In response to the submissions made by learned counsel for the learned additional public prosecutor, the learned counsel for the petitioner has submitted that the division bench of this court in the case of CBI versus Party to Likhibo. NIA versus Ang Min Lane Mate alias Lenin Mate Supra. The division bench has not clarified that the requirement of furnishing grounds of arrest under section 47 of the BNSS is still there. However, it has clarified that if same may not be communicated immediately, it shall have to be furnished within a reasonable period of time. Stop. I have considered the submissions made by learned counsel for both the sides and have gone through the materials available on record. In this case, on perusal of the records, it appears that in this case, there is nothing apart from the WT messages sent to the officer in charge of jurisdictional police station, where the family members of the petitioners reside. And on bare perusal of said WT message, it is apparent that the said WT message is intended to communicate only the fact regarding the arrest of the petitioners and it is devoid of any grounds for which the petitioners were arrested in the aforesaid cases. Stop. There is also nothing to show that the said WT messages, that in pursuant to the said WT messages, the officer in charge of Balidi police station as well as Bihia police station have communicated the fact of arrest of the petitioner to their family members. Stop. Thus, it appears that there is non-compliance of as regards communicating written grounds of arrest to the friends, family members, nominated persons of the petitioners as mandated by the apex court in the case of Vihan Kumar versus State of Haryana. I'll continue with the dictation. I'm allowing the bail application. I'll complete the order in the chamber.
Deeply obliged, sir.
Lordship, in item number 46, the learned AG, while hearing the matter, had placed a press note before your Lordship. We don't have a copy of that. That's the original copy with you. Can we make a copy of it?
Which item number?
46, your Lordship. Supply list.
So, what do you want?
Lordship, the AG, senior counsel had placed the press note before your Lordship. That's the original copy. We just wanted to make a copy of it.
Press note.
Yes, your Lordship.
You can take back the press note. Keep the photocopy in the records.
Maybe. Item number 38. I'm appearing from the special possibility if it is a vigilance sale. The petition is only on interim bail. Case that is not available because up to that case that is not there. So a lot may fix after a week or so.
Item number 38. Heard Miss, what is your name?
R.S. Deori.
R.S. Deori, learned counsel for the petitioner. Also heard Mr. P. Kotoki, learned special public prosecutor, same vigilance cell, who submits that, who prays for some more time for producing the case diary.
Yes.
The prayer is allowed. Let this matter be listed when?
Your Lordship may
And
take
date the
after 2 weeks, my lord.
24/9/2025. The interim order shall continue till next month.
Obliged.
Yes.
Was elected on April 2023 as of date for 2 years, 5 months, 16 days.
18/3.
18/3 of the
2 years.
5 months, 16 days.
Yes. This is your first bail application.
All the my submission is all the exit button have been standard on the
Where are the any bail order of the other accused person? Where? Page number?
No, look, that has not been annexed because it has been recently it was they were granted the
Yes, miss.
Another point is that my submission is on the ground of parity and maybe considered. Another one point is that look,
Parity is no ground. First, you have to mention the grounds. One is prolonged incarceration.
Page number 67, the arrest number. The arrest number grounds are not proved. Page number 67.
And whether in notice was given.
So this is clear violation of the
Two grounds. Yes, Miss Dick. Kakoti. Okay, okay. Miss Kakoti, what is your submission?
Chief, about notice 50 lordship, see our objection lordship. Page number lordship. 88 lordship.
Page number
88 lordship.
objection কোথায় আছে? উপরতে আছে। Yes,
Para 12 lordship. May I read, please, lordship?
yes.
That on the basis of voluntary statement of Sombhunath Prasad and other corroboration evidence, sufficient ground of count of arrest Sombhunath Prasad. Sombhunath Prasad was arrested on so and so date, Narcotics Control Bureau Office, Guwahati, for violence section so and so, punishable section so and so, NDPS Act so and so. All informative should be done during the arrest, like notice section 50 CRPC and section 47 and 48 issued to individual and informed to his wife through telephone.
Where is notice under 47? You have copy of the notice?
No lordship.
Okay. Any other submission? Okay, okay. No, let Ms. Kakoti submit.
Also, para 13 lordship. Sombhunath Prasad confessed his voluntary statement record section
Okay,
67.
professional statement.
He was
Anything?
tracking of commercial quantity so and so kg of ganja, seized in instant case of crime number so and so lordship.
Any other submission?
Also delay in trial on several that they were to taking time lordship.
They took adjournment. Okay. Okay, heard. Mr. K.K. Hendik, learned counsel for the petitioner. Also heard. Miss N. Kakoti, learned counsel for NCB or DRI?
NCB lordship.
Learned counsel for NCB. This application under section 483 of BNSS 2023 has been made by the petitioner, namely Shambhunath Prasad, who has been detained behind the bars since 18/3/2023 within bracket for more than 2 years, 5 months in connection with NDPS case number 133/2023 under section 20B to C/29 of the NDPS Act, pending before the Court of Learned Additional Sessions Judge number 2, Kamrup Metro at Guwahati. The gist of accusation, Code Para 3 from bail application number 2023/2025. It is in the record. I have flagged market. Code Para 4. Court learned counsel for the petitioner has submitted that nothing was seized from the possession of the present petitioner. How many witnesses have been examined? Nothing has been seized from the possession of the present petitioner. However, he has been languishing behind the bars for more than last 2 years, 5 months Stop. He also submits that till date, only 3 out of 13 prosecution witnesses have been examined. And and at the pace in which trial is presently going on, there is unlikelihood of an early culmination of trial. Learned counsel for the petitioner has submitted that due to long incarceration of the petitioner, his fundamental rights guaranteed to him under Article 21 of the Constitution of India has violated, and as such, the embargo of Section 37 of the NDPS Act has been overridden, RIDDN, in this case, and on that count, he is entitled to get bail. Learned counsel for the petitioner has further submitted that in the instant case, the petitioner was not served with any notice under Section 50. Neither the notice under Section 50A of CRPC was furnished to any of the friends or relatives of the present petitioner. And therefore, there has been a violation of fundamental rights of the petitioner under Article 22 within bracket 1 of the Constitution of India, which also entitles him to get bail in this case. He further submits that in the meanwhile, how many accused? All have been granted.
Already 6 have been granted.
In the meanwhile, 6 other co-accused persons have already been granted bail. Stop. On the other hand, learned counsel for the NCB has opposed the grant of bail to the present petitioner. She has submitted that the contrabands seized in this case is of commercial quantity, and therefore the embargo of Section 37 of the NDPS Act is applicable to this case. She also submits that delay in the progress of the trial has also been caused by the frequent adjournments taken by the defense counsel during trial. Stop. She also submits that in this case, at the time of arrest of the petitioner, all the procedural requirements have been complied with by the NCB. She also submits that the petitioner has, during recording of his statement under 67 of the NDPS Act, Section 67 of the NDPS Act, has confessed to the guilt regarding his complicity in the offense alleged in this case. She therefore submits that the prayer for bail may be rejected. Quote para 12. Quote para 13, 14 from the 15 earlier quoted case. 16. Period of detention shall be 2 years, 5 months. Next para. Considering the fact that the petitioner has been found entitled to get bail on the ground of prolonged incarceration, the other ground taken by the petitioner, that is violation of his fundamental right guaranteed to him under Article 22 within bracket 1 of the Constitution of India is not discussed in this bail application. In view of above, the above named petitioner code 18 is allowed to go on bail of rupees 2 lakhs with 2 sureties of like amount, subject to the satisfaction of the trial court bill. This bail application is accordingly disposed of.
Obliged, Lordship.
Bail hearing, item 31.
Can it be after some time?
31.
None appears for the petitioner.
None appears for the petitioner on call. Learned additional public prosecutor has case diary is there.
Yes.
They have complied with.
Actually, KK Parasar has gone through it, Lordship.
Has produced the case diary. Let this matter be listed on Tuesday. Tuesday is 9th. Let the case diary be retained till that.
Item 32.
Here, Lordship, the
Not summary, only on the ground of minor that he's having the, but now he developed under some stroke mild. And we getting certificate also, and again, he was admitted, again, he was, only on that ground, I have nothing to say on that.
No, whether on that ground.
No, this is your worship, because otherwise you will be available, my lord. I am not, because since 2 times he was rejected. So naturally, my lord, I do not accept this, there is no other ground.
Now, what is his condition?
Your worship, kindly see the latest one, I have just given.
No way, he is not in jail, no?
Not in jail. B.
What is the offense?
Again. When see my lord, your worship will find.
POXO. Who is appearing for the?
As per office note 19825, service is complete.
Nobody is appearing. Let us appoint one. Amicus. If Amicus, you are appearing.
Appointed although.
Prohibited?
I was not although appointed, your lordship. I may appointed, your lordship, in this case, your lordship. Earlier, I have not been appointed
No,
in
no,
this
this
matter.
yes,
Afresh, I can.
Okay, what is your name?
Pidas Priyakis.
Heard Mr. H.R.A. Chaudhary, Learned Senior Counsel. Your name is there in the panel.
Yes.
Okay. Learned Senior Counsel assisted by Mr. M.H. Laskar, Learned Counsel for the petitioner. The Learned Additional Public Prosecutor submits that the petition, that the notice issued to respondent number 2 has been duly served. So, however, as no one has appeared for the petitioner number 2, this court intends to appoint one amicus curiae to defend the cause of respondent number 2 in this case. Accordingly, Ms. Priyanki Das, whose name appears in the list of amicus curiae prepared by the registry, is hereby appointed as amicus curiae to defend the cause of respondent number 2 in this case. The petitioner is directed to furnish a copy of bail application along with annexures to the newly appointed amicus curiae during the course of the day. Learned Additional Public Prosecutor submits that case diary is available. Same shall be retained till the next day. Suggested date, next week. 11th. 11th. Let this case be listed.
10, my lord.
10th. Let this case be listed on 10th of September.
Obliged.
Item 33.
May I please, Lordship, learned special public prosecutor, Mr. Dixit Gogoi informed he had some personal difficulties, Your Lordship, today.
Oh,
Mr. Dixit Gogoi, Your Lordship. Special public
oh,
prosecutor.
he has informed you.
Yes, Your Lordship.
Okay, we'll fix another date. Heard Mr. What is your name?
MD A. Rahman, Your Lordship.
Heard Mr. A. Rahman, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. It is submitted at bar that learned special public prosecutor wildlife, Mr. Dikshit Gogoi, has informed that he has some personal difficulty today and therefore an adjournment is prayed for. Stop. The prayer is allowed. Let this matter be listed on 17. Short. 11th of September.
Hi, Lord.
Learned additional public prosecutor submits that the case diary is available. Stops. Same shall be retained till next date of hearing. List accordingly.
Hi, Lord.
44.
That please, Lordship.
It is, Lordship.
It is anticipated bail application. Earlier interim bail is granted by the Lordship, and as per the direction he appeared before the investigating officer.
Has he appeared?
He appeared, Lordship, but he violated the condition, Lordship.
How?
Lordship, violating the condition of the bail is threatening the victim, informant of the instant case to withdraw the FIR. Regarding this threatening, an FIR has already been lodged before our police station on 1925. That FIR is here in this case diary, Lordship.
Oh,
And sufficient materials are also there, Lordship.
then-
Interim may be vacated.
Then you are not entitled. What is your submission? You have threatened the victim. It is a POXO case.
Not POXO case. It is cheating and forgery. The allegation is cheating and forgery. Lordship, the which section is registered, Lordship? It is
But
not.
you have threatened the victim.
Yes, sir.
But
They
it
have
is
lost
a-
FIR in this regard,
it is
and
not
that FIR is here in this case diary, Lordship.
FIR is also there.
Yes, sir.
What is the PS case number? Copy of FIR is there.
Yes, sir.
Then it has to be vacated. Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. N. Das, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Abdul Rauf Ahmad, who was apprehending arrest in connection with Tarabari PS case number 27/2025 under section 319 within bracket 1/336 within bracket 3/340 within bracket 2 of BNS.
15.
Learned counsel for the petitioner has submitted that the petitioner was granted interim bail by order dated 19/7/2025. And in pursuant to the directions of this court, the petitioner has appeared before the investigating officer and has complied with the directions of this court and has cooperated in the investigations. On the other hand, learned additional public prosecutor has produced the case diary of Tarabari PS case number 27/2025 and has submitted that though the petitioner has appeared before the investigating officer, however, he has violated the condition number 1 imposed on him while granting interim bail to him, as he has threatened the victim to withdraw the case against him. She submits that in this connection, who has lost the affair?
Lordship, Ramena Ahmed, Seema Barua,
Inwara Ahmed.
The informants
Hmm.
have also lodged an FIR before the officer in charge of Tarabari Police Station on which date?
On 1/9/25.
On 1/9/2025. She submits that there is endorsement made in the case diary by the investigating officer endorsing the said fact. Hence, she prays that the interim order may be vacated and the prayer for anticipatory bail may be rejected. I have considered the submissions made by learned counsel for both sides.
This FIR has been lodged 1/9/2005. Now today is 4. It may be there is some.
After granting interim protection laws.
Already his statement has been recorded.
No, but
That is right, Worship, but it is just, it is.
GD number is there, Lord.
stop. It appears from record that while granting interim bail to the petitioner, this court had directed that the petitioner shall not directly or indirectly make any inducement, threat, or promise to any person who may be acquainted with the facts of the case, so as to dissuade such person from disclosing such facts before the investigating officer, and he shall cooperate in the investigation. However, from the case diary, it appears that he has violated the said condition, as grant of anticipatory bail is discretionary in nature. The petitioner has to be clean on his part before he can avail and the benefit of anticipatory bail. In the instant case, considering the materials against the petitioner in the case diary, this court is left with no other option but to vacate the interim bail granted to the petitioner by order dated 19/7/2025 and dismiss this anticipatory bail application, which this court accordingly, this bail application is accordingly dismissed. Send back the case diary.
Item 45.
There was an interim order dated 21/7/2025. So there was no specific direction to appear before the IO. And the Lordship, I have already appeared before the IO on 15/6/2025, 19/6/2025, 26/6/2025, 22/7/2025. On 4th occasion, I have already appeared, Lordship. Subsequently, Lordship, the section 7 and 13 of the PC Act were added into the case. And at that point of time, Lordship, we approached before this honorable court. And accordingly, the order dated 21/7/2025 was passed by this honorable court, Lordship. May I take your Lordship to the FIR? Lordship will find it at page 13.
Okay, no, has he appeared?
She appeared, statement recorded, but Lordship materials are there against her.
She's lady.
Lordship, she has already retired from the service, Lordship, on
Okay.
36/2025.
Heard Mr.
He does not.
P. Das, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner Srimati Nijora Kolita was granted interim bail by this court by order dated 21/7/2025. And on these 4 occasions, you appeared
Lordship.
before this or after?
Prior to filing of this application, madam, because there was no specific.
And after this?
Lordship, we have communicated, but my statement was not recorded. We have communicated the.
And the petitioner has complied with the directions of this court. He submits that even before filing of the instant anticipatory bail application, the petitioner appeared before the investigating officer on 4 different occasions. Stop. He submits that as the petitioner is cooperating in the investigation and is ready to continue to cooperate in the investigation, the interim bail granted to her may be made absolute. Stop. On the other hand, learned additional public prosecutor has produced the case diary of Sangsari PS case number 129/2025 and has submitted that though there are incriminating materials against the petitioner in the case diary, however, it appears that she has appeared before the investigating officer and her statement has also been recorded under section 180 of the BNS. Considering the fact, no, I have considered the submissions made by learned counsel for both sides and have perused the case diary. Stop. Considering the fact that the petitioner has complied with the directions of this court and has cooperated in the investigation, the interim bail granted to her by this court on 21/7/2025 is hereby made absolute with condition number 1 and 2 attached to the said order remaining intact. Send back the case diary. This anticipatory bail application is accordingly disposed of.
Obliged, Lord.
May please, your Lord. Anticipatory bail application CD is called for money for the second time.
Second officer.
Although in this case, when I applied for an interim, the petitioner is a lady and she is pregnant. I received some medical documents, my lord.
What is the offense?
Offense is, my lord, POXO is also involved, but here before your lord is a lady, my lord. So necessarily POXO will not come against her. And other sections are, my lord.
No, why POXO will not come?
POXO is against the co-accused, my lord. Name is Zahirul. CD is called for today, second time, my lord, second CD is not available, and the petitioner is my lord, pregnant lady, my lord. Almost 5 months pregnancy, my lord.
Notice to respondent number 2.
My lord, there is a office note, my lord.
Service complete, Lord. Service report is there, Lord.
We'll appoint one amicus.
See there, I have the documents, my lord. Original was with me, my lord. Fellowship.
Is there?
Is there not received, my lord?
CD
Second
not
time, my
received,
lord.
Lord. He
The
is,
second time.
she is outside, Lordship. Let
Where?
the CD come, Lord.
It's an anticipatory bill, that's why I'm paying for interim.
Where are you?
My lord. I'm outside, my lord.
Outsider means?
Some, my lord. I'm not in custody, my lord.
Where do you stay?
And now in a Nalbai. Presently, our home is at here, my lord, in Guwahati, my lord. But because of the apprehending arrest, my lord.
Heard Mr. KK. Heard Mr. MAI Hussain. You are MAI Hussain. There is another MAI Hussain.
I am AI. Yes, I have noticed, my lord. There is another MAI Hussain.
Yes, you are MAI Hussain.
MAI.
Heard Mr. MAI Hussain, learned counsel for the petitioner. Also heard Miss N. Das, learned additional public prosecutor, who submits that the case diary is not available. She also submits that notice to respondent number 2 has been served in this case. What is her name?
Respondent.
That counsel, Miss
Yeah.
Priyanki Das. You appear in this case also. None has appeared for the respondent number 2. Therefore, this court is inclined to appoint one amicus curiae to defend the cause of respondent number 2 in this case. Accordingly, Ms. Priyanki Das, learned counsel whose name appear in the list of amicus curiae prepared by the registry, is hereby appointed as amicus curiae to defend the cause of respondent number 2 in the case. The petitioner is directed to furnish copy of the bail application along with annexures to the petition, to the newly appointed amicus curiae during the course of the day. The registry is directed to reflect the name of Ms. Priyanki Das as amicus curiae in the cause list, in this case henceforth. Yes, any submission regarding interim bail, Ms. Das? Additional PP.
So what is the application?
When is your date, expected date of delivery?
In my lord, not get that instruction, my lord. But,
Short date may be
others-
given, your lordship, considering your lordship as I am appearing for the first time, your lordship.
Because of
Okay,
so that
when
I
can you produce?
Short date may be given.
From
your
our to be lordship, today is 4.
11.
11.
Oh. On the day, city will not come, my lord, interim may be
No.
considered, my lord, on that day.
Yes.
Issue reminder for the case diary. List this case on 11th of September. You take back the original. You can write the book.
Item 47.
It is.
Lordship, this is a previous bail application, lordship. In this case, lordship, the present petitioner is a bank employee, lordship. And kindly come to page number, lordship, 14, the FIR, lordship, and first. And original vernacular, page number 21, lordship. And the conduct of the informant father, lordship, and he obtained fraudulently and cheatingly, lordship, and the loan in 4 times in different banks, lordship. First, lordship, page number 21, lordship, the original one, lordship. Original one. And he obtained the loan in 4 numbers of bank, lordship. First, lordship, and he obtained loan from the informant father. But he is from Hivagar, lordship. And subsequently, he obtained loan from the lordship and the Hivagar and lordship from SBI Bank, Amingao, Kamrup. So, my lord, kindly come, 21, lordship, may I read, lordship?
Yes.
Petitioner involvement is, lordship.
Who are you?
I am, lordship, bank employee, lordship, assistant manager of SBI Bank, Thing branch, lordship.
What is the accusation against you?
It's nothing, lordship, only my name is in the FIR, lordship, serial number is 7. And more than, lordship, and total 7, and my number is 7. But my involvement part is nothing, whisper anything, the contents of the FIR is, lordship. Well, I do not know, I'm very short and surprised, lordship, when my name is why in the FIR, lordship. Otherwise, lordship, the contents of the FIR does not disclose any whispering against me, lordship.
Read the FIR.
May, lordship. সন্মানপূৰ্বক বিনীত নিবেদন এই যে মোৰ দেউতা শ্ৰীযুত ঘন বৰুৱা এজন চৰকাৰী প্ৰাথমিক বিদ্যালয়ৰ শিক্ষক। তেওঁ মাইভেলাস্তি APGCL কৰ্মচাৰী পদ্মা ফুকনে লোনৰ কাম কৰা ব্যক্তি হিচাপে ভৈৰৱ গগৈ নামৰ এজন ব্যক্তিৰ লগত চিনাকি কৰাই দিয়ে আৰু সঞ্চয় এমাউন্ট টকা লোন এটা গ্ৰান্ট কৰা বুলি কৈ 2/8/2021 লৰ্ডশ্বিপ তাৰিখে খুৱাং SBI বেংকলৈ মাতে আৰু 3খন সহি কৰা ব্লেংক চেক লয় আৰু কয় যে যেহেতু তেওঁৰ আগৰে পৰা 3টা লোন চলি আছিল গতিকে সকলো এডজাস্ট হৈ যোৱাৰ বাবে লোন লৈছিল যদি একাউণ্টত বেছি টকা জমা নোহোৱা বুলি কয় পিছত জানিব পাৰো যে ইতিমধ্যে ভৈৰৱে
me lordship. Bhoirabe 85,000 toka uliai loi. And second part lordship, পিছত পুনৰ নাজিৰাৰ পৰা ICICI বেংকৰ পৰা লোন দিয়াব পাৰিব বুলি ভৈৰৱ গগৈয়ে কমল শইকীয়া, কেশৱ গগৈ আৰু মিলি উপাধি এজন ব্যক্তিৰ সৈতে দেউতাক চিনাকি কৰাই দিয়ে আৰু সেই অনুসৰি 31/12/2021 তাৰিখে বেংকলৈ মাতি 21 লাখ টকা লোন চেংচন হোৱা বুলি কয় আৰু কমলজিৎ শইকীয়া দেউতাৰ আগৰে পৰা লোন ক্লোজ কৰিবলৈ বুলি SBI খোৱাং ব্ৰাঞ্চত 600 টকাৰ আৰু এক্সিছ বেংকত সোণাৰী ব্ৰাঞ্চত 600 এমাউণ্ট টকাৰ চেক জমা দিবলৈ বাধ্য কৰে। পাছত পুনৰ 4/1/2022 তাৰিখে ভৈৰৱ গগৈ দেউতাৰ পৰা এখন চেক যোগে 4 লাখ টকা উলিয়াই লয় আৰু যিহেতু হাউচিং লোন আছিল বুলি গতিকে বেংকত জমা দিয়া ড্ৰয়িং অনুসৰি ঘৰ সম্পূৰ্ণ কৰিবলৈ পৰামৰ্শ দিয়ে। এমাহৰ পাছত পুনৰ ভৈৰৱ গগৈ আহি ঘৰৰ কাম সম্পূৰ্ণ কৰিব নোৱাৰিলে বেংকে কেছ দিব বুলি ভাবুকি দিয়ে। তেতিয়া দেউতাই ভৈৰৱক উপায় বিচৰাত গুৱাহাটীত মহন্ত নামৰ এজন ব্যক্তিয়ে পাৰ্চনেল লোন দিব পাৰিব বুলি কৈ দেউতাক গুৱাহাটীলৈ লগ ধৰে। সেই অনুসৰি ভৈৰৱে দেউতাক গুৱাহাটীলৈ লৈ যায় আৰু বশিষ্ঠ চাৰিআলিত থকা ববি লজত ৰাখে আৰু 1/3/2022 তাৰিখে আমিনগাঁও SBI বেংকত এগেইন 600 এমাউণ্ট টকা লোন চেংচন হোৱা বুলি কয় আৰু পাছত দেউতাৰ পৰা চেকত চহী লৈ 8 লাখ টকা উইথড্ৰল কৰায়। উক্ত লোনটোত ভৈৰৱ, মিলি, কলিতা আৰু মহন্ত মুঠ 6 লাখ টকা লয় আৰু পাছত আকৌ 1,30,000 টকা লয়। সেই সকলো কথা কাৰো আগত ব্যক্ত নকৰিবলৈ ভাবুকি প্ৰদান কৰে আৰু লগতে কাৰোবাক ক'লে কেছ কৰিলে দেউতাৰ লগতে পৰিয়ালটোক ধ্বংস কৰিব বুলি কয় আৰু কয় মহন্তই ডাঙৰ লোন এটা প্ৰায় 45 লাখ টকাৰ ঠিক কৰি দিব আৰু সকলো ঠিক হৈ যাব। নেক্সট পেজ লৰ্ডশ্বিপ। কিন্তু দেউতাই ইতিমধ্যে সকলো ফালে ধাৰত পোত গৈছিল আৰু সেই ভৈৰৱক ফোন কৰি সোনকালে ঠিক কৰি নিদিলে কেছ কৰিব বুলি ভাবুকি দিয়ে আৰু সেই ভাবুকিৰ পৰিপ্ৰেক্ষিতত যোৱা 2022 চনৰ ডিচেম্বৰ মাহত 4 তাৰিখে ৰাতি 8টা মান বজাত ভৈৰৱ কলিতা আৰু এজন অজ্ঞাত ব্যক্তি আহি বন্দুক দেখাই দেউতাৰ লগত মোক প্ৰাণে মৰাৰ ভাবুকি দি যায়। গতিকে প্ৰাণৰ ভয়ত আমি কথাবোৰ কাকো নজনাও। ভৈৰৱে পুনৰ 45 লাখৰ লোনটোৰ বাবে মহন্তক 2.5 লাখ টকা লাগিব বুলি কয় আৰু দেউতাক নগাঁও ধিং SBI বেংকলৈ লৈ যায়। তাত 23/2023 তাৰিখে 600 এমাউণ্ট টকা লোন চেংচন কৰা আৰু উক্ত টকাখিনি লয় আৰু 15 দিনত ডাঙৰ লোনটো হ'ব বুলি কয়। পিছত 15 ডেজ উকলি যোৱাৰ পিছত ভৈৰৱে আকৌ মোৰ পৰা লোনটোৰ বাবে টকা লাগে বুলি কৈ 1 লাখ টকা বিচাৰত দিবলৈ বাধ্য কৰোৱায়। দিন বাগৰি যোৱাৰ লগে লগে গোটেই পৰিয়ালটো জড়লা হৈছো। So this is the allegation, lordship. But only my name is last serial number C at that time.
Whether any loan was sanctioned from Dhing SBI?
There is nothing. If there is anything, it will be.
Okay, why are you apprehending your arrest? Because your name is there.
My submission, lordship, and loan authority in the bank, lordship. There are two parts, lordship, housing loan and other. These are the separate employee. They will be sanctioned and they will be approved. And subsequently, it will be forwarded to the head office of the SBI Guwahati. And when head office will be approved the documents, and again it will be sent to the branch.
Otherwise, lordship, main allegations against Bhoirav Gogoi.
Against him?
Witness is not implicated.
Heard Mr. H. Heard Mr. F. Learned counsel for the petitioner. Also heard Ms. Indas, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Bani Pathak, alias Bani Brata Pathak, who is apprehending his arrest in connection with Mathurapur PS case number 4/2025 under section 308 within bracket 4/331 within bracket 4/318 within bracket 4/111 within bracket 2 of BNS, read with section 25 within bracket 1A, capital A/35 of the Arms Act. The gist of accusation in this case is that on 9/3/2025, one one Dipankar Barua lodged an FIR before the officer in charge of Mathurapur police station, inter alia, alleging that one Bhairav Gogoi, named in the FIR as accused number 1, used to asked Bhairav Gogoi, who has been named as accused number 1, used to meet his father of the informant Ghana Gogoi, and assure him to get loan from bank on various occasions. And it is also alleged in the FIR that every time when a loan is sanctioned, the said Bhairav Gogoi used to take a share out of that loan from which was sanctioned to the father of the informant. In the FIR, accusation has been made that on more than 4 occasions, said Bhairav Gogoi had, on pretext of arranging a loan from bank, had taken money from the father of the informant. Stop. Learned counsel for the petitioner has submitted that. No, before that, it is also alleged that on 4/12/2022 at about 8 p.m., the said Bhairav Gogoi, one Kolita and one unknown person, one person with surname Kolita and one unknown person came to the house of the informant and threatened the informant, his father and his mother by showing a pistol to kill them if they disclose the facts relating to taking of money by the said persons from the father of the informant. Stop. Learned counsel for the petitioner has submitted that the petitioner is a bank employee. He is employed. In what capacity you are employed?
Assistant manager.
Is employed
SBI
in the capacity of assistant manager at Dhing branch of SB, State Bank of India. And he is in no way involved in the offense alleged in this case. He submits that though the name of the petitioner has been mentioned at serial number 7 in the FIR, however, in the body of the FIR, no allegation has been made against the present petitioner. Why are you apprehending? Whether police is searching?
My name is their lordship, but police is.
Stop. However, as the petitioner has been shown as one of the accused in the FIR, he is apprehending his arrest. Stop. Learned counsel for the petitioner submits that the petitioner is ready to cooperate in the investigation and therefore prays for allowing him to go on anticipatory bail. On the other hand, Ms. N. Das, learned additional public prosecutor, has produced the case diary of Mathurapur PS case number 4/2025 and has submitted that there are materials against the accused number 1, namely Bhairav Gogoi, and some other accused persons in the case diary. However, she fairly submits that there is no incriminating material as on date against the petitioner in the case diary. Stop. Considering the submissions made by learned counsel for both sides, as well as after perusal of the case diary, and perusal of the case diary, as there are no materials against the present petitioner in the case diary, the prayer for anticipatory bail is allowed. The petitioner is directed to appear before the investigating officer of Mathurapur PS case number 4/2025 within a period of 7 days from the date of this order and cooperate in the investigation. If he does so within the stipulated period of time, in the event of his arrest in connection with the aforesaid case, he shall be allowed to go on bail of ₹30,000 with 1 security of like amount. With above observation, this anticipatory bail application is disposed of. Send back the case diary.
Deeply obliged, Lordship, deeply obliged.
Ordered item 39. Please, Lord. In this case, prisoner before Lord, he was an informant, my lord. But he filed a case before regarding forgery of his document, my lord, for the concerned police station, my lord. But no seizure has been taken place. And that document has been used, that is registered as reported PS case number 114 of 2024, my lord. It was registered under 468 and 471 IPC, my lord. But as on today, the investigating officer failed to seize that document, my lord. In fact, the accused person has used the document and filed a civil suit also for recovery of money, man, where my signatures have been forged, man.
No, what relief you are seeking?
My seeking is that since the investigation has come to a grinding halt, nothing has been seized. So I have no other way.
Case diary is there. Whether
I have to get the instructions, Lordship. I am appearing for the official respondents, Lordship. Till respondent number 5, 1 to 5.
and notices have been issued to respondent number 6 and 7.
6 is the investigating officer, man, who is of the case, man, and 7 is the accused person. Basically, my grievance is that nothing has been seized, neither it has been procured, my signatures has been forced, or to have been sent to the forensic laboratory for my after comparison.
Let her take instructions.
Yes.
Heard. And regarding service of notice on respondent number 7.
6 and 7, they have not appeared, Lordship.
6, well, they can also, yes, sir.
I mean, no, instruction 9.
6 actually is the official person, madam. Though he by person I have been named him, madam, but even
Since by name he has been made a party, Lordship.
Why you have made him a party?
because of malafide, my lord, what was his personal interest, has and so on. But that's why that I will as malafide.
No, you don't know how he is investigating.
But in spite of the fact that my signatures have been forced, I have specifically mentioned. But nothing has been done as on today, madam.
Heard Mr. P. Kotoki, learned counsel for the petitioner. Also heard Ms. MDB, learned government advocate appearing for respondent number
1 to 5.
1 to 5. Learned government counsel submits that she may be granted some time to seek instructions in this case, and if required, to file an affidavit in opposition. The prayer is allowed. It also appears that notice issued to respondent number 6 and 7 have not been served. Service report in respect of notice issued to respondent number 6 and 7 has not yet been received. What is to be done? Fresh steps, or you will be away?
Yes, I can take this.
In view of above, the petitioner is directed to take fresh steps for issuance of notice upon respondent numbers 6 and 7 within 7 days from the date of this order by registered post with AD, as well as the usual mode within returnable on 16th of October. List this matter accordingly.
Obliged, Lordship.
And 40.
Putting the fix for response number, service on response number 2 PP, my lord.
Oximeter.
No, also is involved, my lord. To PP and it was served to the PP, whether it need to take the step to PP. And that instruction is everything.
Service report not received, Lordship.
You take in information.
Okay.
You have taken time earlier also
Okay.
to seek instruction. You can telephonically seek instruction,
Lordship. Tomorrow, Lordship.
not tomorrow. 11th. Heard Miss S. Bora. No, sorry, heard Mr. S. Bora, learned counsel for the petitioner. Also heard Miss N. Das, learned additional public prosecutor, who prays for some more time to seek instruction regarding the fate of notice issued to respondent number 2. The praise allowed. The petitioner, the additional public prosecutor is requested to take information regarding the fate of notice issued to respondent number 2 from the officer in charge of jurisdictional police station and let this court know about the same on the next date fixed. Let this case be listed again on 11th of September.
Okay. 41.
My lord, I have, my lord, filed a petition, my lord, for quashing the, my lord, complaint, my lord, filed in Calcutta, my lord, against a loan, my lord. Against a loan, my lord, this loan, my lord, application here, Guwahati, GS branch of GS Bank, and loan disbursed, my lord, here. And my lord, this petitioner also resident of here. And my lord, interesting, my lord, this yes Bank, my lord, they file, my lord, debt recovery tribunal case, my lord, 165, which is still pending, my lord. And debt to my lord,
Who is appearing?
From my account, my lord.
I am appearing for Yes Bank.
Yes,
My lord,
Bank.
from my account, my lord, they are deducting. Day before yesterday, my lord, they deducted moment. Still, my lord, they filed such a case, my lord, and now, my lord, warrant of arrest, my lord, against me. My lord, kindly see, my lord, statement of account yesterday, day before yesterday, it is deducted, my lord. I have also enclosed, my lord, the statement of account in my affidavit, my lord.
Where is the case pending?
It put Calcutta, my lord. And no, there is no, my lord, way to file, my lord, case in Calcutta, my lord.
Why?
Because, my lord, everything here Guwahati. The branch is Guwahati, I am Guwahati, loan disbursed in Guwahati, DRT, my lord, filing. And interesting, my lord, while filed the, my lord, complaint in Calcutta, they suppress about the pendency of the, my lord, the tribunal case. My lord, kindly see, my lord, this their complaint, my lord, it is there, my lord. Page, my lord, page, my lord, 73. Peculiar type of, my lord, conduct of US Bank, my lord. Parallelly, there file their recovery tribunal case and their, my lord, for recovery, my lord, in Calcutta, and they are also deducting every month on the 2nd of every month they are deducting, my lord.
No, have you taken steps for
My
issuance of?
lord, by speed post, my lord, I have taken, and my lord, one, my lord, here, because my lord, they refused to take dusty service, one person is, my lord, received, and I have my respondent number 2. I have, my lord, filed affidavit in this regard. Kindly see, my lord, one thing, page 81, my lord.
No, before we go into the merit, let us see whether service is complete or
My lord, friend appearing, my lord.
appearing for respondent number 3.
Bank, my lord, bank, the officer can represent, my lord.
1, 2, and 3. Okay.
Need some time for the instruction, lordship.
No, what about warrant, my lord, can you see para 2, my lord, of my affidavit, my lord, page 78. My lord, Hatiga.
No, no. Can you file a writ petition before Guwahati High Court for quashing a matter?
Because
which is
I obtained loan Guwahati.
maybe,
Here, my lord, and disburse here, there, my lord, they filed.
but you are challenging the note.
My lord, writ petition, my lord, the inherent power is there, lordship, my lord. My lord, that court has no jurisdiction.
That you have to plead before Calcutta High Court.
My lord, this court can interfere because, my lord, from there, my lord, document, I can show, my lord, everything here, my lord. That court has no jurisdiction. And that to suppressing the DRT case, my lord, they file in Calcutta Magistrate Court, my lord. Two
How
parallel.
How much time you will require? When is the next date fixed? Before,
Next day, in DRT, my lord, it is fixed.
not DRT.
There, my lord, I am not aware because, my lord, warrant is, my lord.
So we are giving,
against me by my lord, Hatinga police harassing me, my lord. I have stated in para 2 of my affidavit, my lord. At page, my lord, at page, my lord, 78.
para 2 where?
In 78, page 72, my lord, that there is certain development in the case, the court number 70, Judicial Magistrate Calcutta issue warrant of arrest which is reached Hatinga police station on 29/8/25.
No, but this is not the appropriate case. Unless we peruse the records of the case in which impugn order has been passed. And therefore, this court can exercise jurisdiction.
It is there, my page, can you see, my lord, page 73. Page 73, the summon, pen 74 is the copy of the complaint.
No, we don't know on what basis summons have been issued. Records are not before us.
On the basis of, my lord, this complaint case, my lord, page 74. Under, my lord, under section 25 of Payment of Settlement System Act 2007. My lord, there is system of transferring amount, my lord, by electronic way. There is no dispute, but, my lord, they are deducting, my lord. Day before yesterday they deducted the amount, and for that amount, my lord, they filed a complaint case. And another case, DRT here. DRT next date is 15 October, my lord. They are taking time, my lord, in the DRT case for filing in general. Because, my lord, I disclose everything in my WS, then, my lord, they surprised. And now they are taking time. 4 times they have taken for filing rejoinder. They cannot.
No, you have to answer the basic questions. This court can exercise jurisdiction over the territorial limits over which this court may exercise its
My lord,
jurisdiction.
power, my lord, can be exercised.
No, let me put a question. Suppose a person files wrongly a case before court in West Bengal, which is the appropriate in a magistrate court in West Bengal. And the magistrate court takes cognizance of that offense. Which is the court where you can challenge that order?
My lord, I can file here also, there also,
Show
even
me.
in the Honorable Supreme Court also.
Show me.
Then, my lord, it can be Monday, my lord.
No, let her take instruction also within 7 days.
But I just see there because, my lord, warrant of arrest is there. And without any reason, my lord, they are about, my lord, every month, on 2nd of every month, they are deducting from my account.
We are not going into facts without ascertaining the jurisdiction of this court. Heard Mr. S. Chauhan, learned counsel for the petitioner. Also heard Miss, what is her name? S. Yasmin, appearing on behalf of Mr. M. Sharma, learned counsel for respondent number 1, 2, and 3. Stop. Who prays for some time to get instructions in this case, necessary instruction in this case, the prayer is allowed. Since in this case, the prayer of the writ petitioner is for quashing of
My lord, criminal petition.
in this criminal petition for quashing of a complaint case bearing case number CS 66696 2025 pending in the court of 17 Judicial Magistrate Kolkata has been made, and as said court is beyond the territorial jurisdiction of this court, a query was posed to the learned counsel for the petitioner regarding jurisdiction of this court to entertain the instant criminal petition under section 528 of BNSS. On this, learned counsel for the petitioner sought some time to answer to the said query. The prayer is allowed. Let this matter be listed on 22nd of September.
My lord, warrant is
Shorter
there, my
date,
lord, so
shorter
time
date.
is big.
16th of September.
42.
May I please your lordship? This IA has been filed for modification of the connected BA 2434, your lordship, wherein in the cost title page, there is one typographical error in the FIR number, your lordship.
The case is pending.
Yes.
It is pending. Bail application is okay. ISO. What is your name?
S.J. Chaudhary.
Heard Mr. S.J. Chaudhary, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. This interlocutory application has been filed by the petitioner praying for amendment of typographical mistake in mentioning the FIR number in the said in the cost title of the said bail application. It is submitted by learned counsel for the petitioner that the FIR number has been mentioned in the bail application as Paltan Bazar PS case number 197/2023. However, the actual and correct FIR number is Paltan Bazar PS case number 193 of 2023. As the said correction is, as the said mistake has been committed inadvertently due to typographical error, he prays for allowing the petitioner to correct the same by filing an amended cost title. Learned additional public prosecutor does not oppose the prayer. Stop. Considering the submissions made by learned counsel, the prayer is allowed. And this interlocutory application is disposed of. You will file fresh?
That's
No, first you amend the petitioner shall submit an amended cost title in the connected bail application number 2434 2024, and thereafter within 3 days from the date of this order, and thereafter take fresh steps for service of notice on respondent number. Which respondent?
Prakash Mandal. At page 3 of the bail application.
Respondent number 2. Within 7 days from the date of filing of the amended cost title, returnable on. No, Lambade.
22.
Given 22 September 2024, 2025. This interlocutory application is accordingly disposed of.
Acha.
During item 40 and 44.
Lordship will take up 44.
Yes.
May I please, your Lordship? Lordship will take up, I think, about 44, my lord.
44.
44, my lord. It is the
Item
first
number.
petition, my lord.
Which one should I take?
44. 44. It is the first petition. This is a case of concurrent finding, my lord, NIA case. So they have filed 44 revision against assailing those judgments, my lord.
44 is criminal revision petition number 159.
159 and 17.
Yes. Yes.
May I please, your Lordship? This revision prefer against the impugned judgment and order dated 11/7/2017 passed by the learned session judgment. Affirming the judgment and order passed under section 138 of NI Act, whereby the petitioner was sentenced to undergo simple imprisonment of 1 year and pay 6,50,000 as compensation on account of dishonor of the check issued by the petitioner. Here, my lord, the prosecution story started, my lord, with the lodging of a complaint before the learned court of Chief Judicial Magistrate Nagaon on 17/3/2011. Here, the petitioner has borrowed an amount of 5 lakhs from the complainant by executing a hand note in presence of witness with a promise to return back on or before 17/5/2011. Earlier, also, petitioner borrowed 1 lakh and has been returned in case to the complainant. Here, the petitioner failed to return the money. He filed an FIR before Nagaon PS, my lord, under section 406 and 420 IPC. Here, the petitioner was granted bail on 23/5/2017 from the High Court. So here, my later the petitioner was taken cognizance under section 138 NI Act by the trial court. My lord, during the course of trial, the prosecution side examined 3 witnesses. 3 prosecution witness and 1 defense witness. And CJM Chief Judicial Magistrate Nagaon convict the petitioner to undergo simple imprisonment of 1 year and pay 6,50,000 as compensation under section 138 of NI Act. And then after convicting by the Chief Judicial Magistrate of Nagaon, my lord, the petitioner filed an appeal before learned session judge Nagaon. And the court ordered order dated 11/4/2017 criminal appeal was pleased to dismiss the appeal, affirming the judgment and order passed by the Chief Judicial Magistrate Nagaon. And then later, my lord, the petitioner approached the High Court, my lord, with this criminal revision petition, my lord, with a ground that, my lord, there are several grounds, my lord. I have pressed on ground number 3, my lord. Here, my lord, the learned court below ignored the evidence of the petitioner borrowed only a sum of 1 lakh, not 5 lakhs. And the issue, Lordship has got, my lord, the ground.
Yes, yes.
And the has passed the learned court referring, my lord, 1 lakh, not 5 lakh. And the issue from no check, and I have given 4 check as a security, my lord. And then, my lord, ground number 6, my lord. Here, my respondent failed to produce any documents to show that he has the capacity to lend money. Neither he produced any kind of trade license.
and I'm pressing ground number 7, my lord. There is a hand note which authorized by one of an advocate, my lord, Rafiq Udin, and the said person was never examined, my lord, during trial.
Why, this is an NIA,
My lord.
NIA case.
Right.
So whether there was dishonor of check or not.
There was, my lord.
Um,
According to the respondent, my lord. But
Okay, what else is your ground?
these are the grounds, my lord.
Lordship, I'm sorry, Lordship, we are just a performer party here, Lordship. Will Lordship be requiring our presence?
No.
May I read, Lordship?
Yes.
This is my case, my lord.
Yes, Mr. Bala.
The gist of the case is that the complainant, from the complainant, the accused borrowed 5 lakhs of rupees. In that regard, when before the borrowing of the, I'll come to all the facts. I'm just giving a brief introduction of the facts. Before this borrowing of this 5 lakh rupees, another 1 lakh rupees was borrowed by the petitioner, my lord. In that context, also one check was issued, my lord. Later, that check also got dishonored, my lord. But that subsequently the payment was made on his part, and this check was taken. Now, for the subsequent 5 lakh rupees, when the payment was not made by him, we lodged an FIR in the police station. So when we lodged the FIR in the police station, and he also managed to obtain bail, there, my lord, he approached us, and the matter was settled between us on condition that he is going to return the money to us. So in that regard, he also executed one hand note, promissory note, and then a deed of compromise was also executed between the two of us, my lord, that he is going to repay this 5 lakh rupees of money. Both of these documents were also exhibited. And for repayment of these 5 lakhs of rupees, my lord, he issued the check in question. And the check was dishonored. That is the fact of the case. Now, in this case, what they have submitted. I've also
So why 2 cases are there?
One case is we have filed seeking enhancement of the quantum of compensation.
Okay, second one.
Second one, the one item number 43. That we have filed because this case was of 2011. Check amount was of 5 lakhs and compensation was only 6.5 lakhs. So we had filed that revision petition challenging the quantum of compensation, that it ought to be twice the check amount. That is the only ground in our criminal petition, my lord, revision petition. Now, as regards their case, my lord, I'll just give the first point which, my lord, they are submitting is regarding what they are trying to seek is reappreciation of evidence, my lord. Under this revision petition, they are seeking basically reappreciation of, when they say that the particular hand note, the maker of the hand note, the advocate who made the hand note was not examined. So basically what they are trying to do is reappreciation of evidence. Now in this regard, my lord, I'm relying on 2 judgments, my lord. Your lordship will kindly come to page 17, my lord, of my compilation. Page 17, this is Veer Singh versus Mukesh Kumar. Your lordship will come to page 24, para 16.
Just a minute.
This was also an NIA case, my lord. In para 16, the Honorable Supreme Court says that it is well settled that in exercise of revisional jurisdiction under section 482 of the Criminal Procedure Code, the High Court does not, in the absence of perversity, upset concurrent factual findings. It is not for the revisional court to reanalyze and reinterpret the evidence on record, my lord. So unless and until the petitioner can show perversity apparent on the face of the record, this honorable court is not required to reanalyze and reappreciate the evidence, which basically they are trying to do.
How to examine perversity?
My lord, for that, my lord, will come to page 32. There's another judgment, my lord, Monjuram Kolita versus State of Assam. Starts page 32, para 9, my lord.
Yes.
Para 9, my lord, third line. First line is regarding the facts of that case. My lord, it is a settled legal proposition.
Yes.
It is a settled legal proposition that if the courts below have recorded the finding of fact, the question of reappreciation of evidence by the third court does not arise unless it is found to be totally perverse. The High Court does not sit as a regular court of appeal,
higher court. Its function is to ensure that law is being properly administered. Such a court cannot embark upon fruitless task of determining the issues by reappreciating the evidence. Next one, para 10. The court would not ordinarily interfere with the concurrent findings on pure questions of fact and review the evidence again unless there are exceptional circumstances justifying departure from the normal practice. The position may undoubtedly be different if the inference is one of law from the facts admitted and proved, or where the finding of fact is materially affected by violation of any rule of law or procedure. Where the court below considered the material facts and did not take into consider any inadmissible evidence, etc., the interference is not required by court on third instance. So it is for the petitioner to make out a case that there is a perversity.
Okay,
on
mayor
the part.
pleading that there is a perversity would
will
not
not
do.
suffice. Sir.
It has to show.
Petitioner has to show exceptional cases where this perversity is writ large on its face, and only in that case this honorable court can go into the merit of the case. Otherwise, my lord, appreciation of evidence, reappreciation of evidence is, my lord, not permitted. Now, the case basically pertains to a dishonor of a check of 5 lakh rupees, my lord. Now, this check was drawn on the petitioner's account. That part is admitted. The branch manager, the assistant manager of the bank, Indian Overseas Bank, Nagaon, my lord, he came in as PW2, and he proved that this account, my lord, was in the name of Tumpa Dresses, and it was operated by the petitioner, my lord. And this petitioner's account statement was also exhibited by the bank manager, and he also proved that there was a deduction of 75 rupees for dishonor of the check from the petitioner's account. In fact, the petitioner also adduced his evidence as DW1, my lord, and there also he admitted. So there is also admission on his part as DW1 that this check in question, my lord, was his check, and that the signatures that were there in the check belonged to him, my lord. Exhibit 3. And the reason why the check was dishonored, my lord, the ground is exceeds arrangement. That is, your lordship, the ground, the dishonor memo is Exhibit 7. So exceeds, if a check is dishonored for exceeding arrangement, my lord, that also comes within the purview of 138 NI Act. And there is a presumption, your lordship knows, under 146, my lord, of the NI Act, the court will have to draw a presumption of law that the grounds which is mentioned in the dishonor memo, unless those are rebutted, that is the ground for which the check is dishonored. So here, check is dishonored for exceeding arrangement. Now, this demand note, after the dishonor, we issued a demand notice within the stipulated time on 29/2011. It was received by the petitioner, my lord. That is also apparent because the AD card was received with his signature, and the AD card was exhibited as Exhibit 10. In fact, the petitioner, he in fact also sent 2 replies to the demand notice. One to the respondent himself and one to his engaged counsel. So the factum of receipt of the demand notice is also, my lord, not in dispute. Now, whether this check was for the discharge for his legally enforceable debt or liability, my lord, again, there is a presumption under 139. Now, my learned friend has not taken the plea here, but the plea is there in their petition that this check was issued as a security check, man. But the plea of your lordship knows that the plea of security check is also not tenable. If the check is issued by them, even if it is for securing any liability, existing liability, even in that case, Section 138 is still attractive.
There is some authority.
Yes, my lord. My lord will kindly come to page 39 and relevant portion, page 42. Paragraph 10. Page 42, paragraph 10. Doctor has it. The language, however, has been rather specific as regards the intent of the legislature. The commencement of the section stands with the words "where any check." The aforementioned 3 words are of extreme significance, in particular, by reason of the user of the word "any." The first 3 words suggest that, in fact, for whatever reason.
Any in Section 138.
This one. In 138, madam, where any check.
Okay.
The user of the word "any," the first 3 words suggest that, in fact, for whatever reason, if a check is drawn on an account maintained by him with a banker in favor of another person, for the discharge of any debt or other liability, the highlighted words, if read with the first three words at the commencement of section 138, leave no manner of doubt that for whatever reason it may be, the liability under this provision cannot be avoided in the event the same stands returned by the banker unpaid. The legislature has been careful enough to record not only discharge in whole or in part of any debt, but the same includes other liability as well. This aspect of the matter has not been appreciated by the High Court, neither been dealt with or even referred to in the impugned judgment. So, my lord, what this judgment says that even if it is discharged for any reason, my lord, if the check has been discharged, in that case, this presumption will still come into play, my lord. So the plea that it was issued for securing a particular liability will not come to their aid unless they can show that at the point of time in which this check was issued, there was no subsisting liability. So presumption will still remain. Of course, it will be rebuttable, but they will have to rebut it, my lord. Now there are two more judgments, my lord, on this point. Lordship will kindly come to page 26, my lord. This is again B. Singh's case, my lord. Para 33, my lord.
Yes.
A meaningful reading of the provisions of the Negotiable Instruments Act, including in particular sections 20, 87, and 139, makes it amply clear that a person who signs a check and makes it over to the payee remains liable unless he adduces evidence to rebut the presumption that the check had been issued for payment of a debt or in discharge of a liability. It is immaterial that a check may have been filled in by any person other than the drawer if the check is duly signed by the drawer. If the check is otherwise valid, the penal provisions of section 138 would be attracted. If a signed blank check is voluntarily presented to a payee towards some payment, the payee may fill up the amount and other particulars. This in itself would not invalidate a check. The onus would still be on the accused to prove that the check was not in discharge of a debt or liability by adducing evidence. It is not the case of the respondent. So this part. And next one will be. So here also, my lord. So if the plea which they had taken was that this was a blank check, this was issued as a security. So this judgment makes it clear that even if a blank check is issued by the payee, my lord, sorry, the drawer of the check, my lord, even in that case, the liability would remain. The presumption under 139 would still survive. My lord. The presumption has to be rebutted by them. The presumption has not been rebutted here, my lord. So two pleas, plea of security check, as well as the plea of having a blank check, my lord. That part, unless and until that presumption is rebutted, my lord, that will survive. Interestingly, in this case, my lord, this petitioner, he filed a petition, my lord. During the trial, he filed a petition for sending the check to the FSL for expert examination. Now,
He is disowning that he has not signed.
Initially, my lord, in his as DW1, he said that this is my check. He's admitted that this is my check, this is my signature. But I do not know why, but he came and later filed a petition saying that this check needs to be sent to the FSL because the contents of the check were not filled up by him. That was his contention, man. So later, this petition was allowed, man. This petition for sending the check to forensic was allowed. And then they again came and they filed another petition where they said that we don't want to send the check for FSL. So they filed a petition saying that let the check be sent for forensic examination. And after it was allowed by the learned trial court, then they came and again filed a petition that no, we don't want the check to go for forensic examination. So in those circumstances, your lordships will definitely take adverse inference against them that why they had to invoke the jurisdiction of a court to pass an order for getting the check forensically examined. And thereafter, they went back and said that no, we don't want the check to be forensically examined. So either in both circumstances, even if it is assumed that the check was blank, signature obviously being admitted, the contents were filled up maybe. In that case also, because of
He has a liability.
Liability will be there.
He has a burden to show that it was not in discharge of a
liability. So even if I fill up the contents of the check, my lord, even in that case also the liability will survive. But in this case, that is not our submission. But in this case, they came up with this contention. They tried to establish it by getting it forensically examined, and later when this was allowed, they backed out. So in these circumstances, your lordship will kindly draw an adverse inference against them, my lord. Now, petitioner's basic plea was that, my lord, that he had taken 1 lakh rupees from me,
Not 5 lakhs.
not 5 lakhs, 1 lakh. That was his plea.
Yes.
Now, and at the time of borrowing the money, he had given 4 blank checks, including, my lord, the dishonored check, which is Exhibit 3.
Which he claims to be security checks.
My lord. And 2 blank signed papers. So, my lord, even if we assume that this contention is correct, even if we assume, so what it means is that they have admitted that they've taken an amount of money. And for that, they have issued a security check. So this check is still securing an existing subsisting liability, even if we go by their contention.
So burden is on them. There.
Burden is on them.
There was no existing
Liability. So they have admitted that it was only in regard rupees 1 lakh. So now the burden is on them to show that it was only for rupees 1 lakh and not 5 lakhs. Because we have come with the check, which is for 5 lakh rupees. They have to show that it was not 5 lakhs, but 1 lakh, which they have not been able to show. Now, in their replies, my lord, which they have sent to the demand notices, they have said that we have a liability of rupees 1 lakh, out of which we have paid rupees 11,000, and there was an existing liability of rupees 89,000. This was their plea in their reply to the demand notice. Now, when they were examined under 313 CRPC, then this plea is not there. That plea goes away. It was in the demand notice reply that 1 lakh was there, 11,000 paid, 89,000 surviving. 313, they don't take that plea. Now, in cross-examining PW1, that is the respondent, there they put a suggestion that the petitioner had 6 months to return rupees 1 lakh, and this 1 lakh rupees was returned in installments of rupees 13,000. So here again, during cross, this plea changes. Here the plea becomes that we had 6 months time to pay the money, and we have repaid the money in installments of rupees 13,000. Again, when this petitioner comes in and gives evidence as DW1, there he says that, okay, we had borrowed 1 lakh rupees. I had 6 months to return the money. I have returned only rupees 13,000. So in cross, they said they had paid off the entire money in installments of 13,000. And DW1,
as DW1,
they say only 13,000 has been paid. And how it has been paid? 3,000 has been paid by himself, and another, the remainder has been paid by through his employee Binoy Das. So he has shown his books of accounts as Exhibit 1. So my lordship will appreciate that there are basically 3 pleas on their part. A plea in their replies where they have said that we have paid 11,000, 89,000 remains. In their cross-examination of my cross-examination, they say that we have paid the entire sum of 1 lakh in installments of 13,000. As DW1, they say that we have only paid 13,000 and 87,000. That is not said, but we have only paid 13,000. So their pleas are inconsistent, and burden would still remain on them to show that this liability was actually 1 lakh rupees and not 5 lakh rupees. That has not been done. And he has gone back to the previous transaction, that 1 lakh rupee transaction. That 1 lakh rupee transaction, we have not suppressed that part. We have admitted that in our complaint.
And that he has paid.
That 1 lakh has been paid.
In case, madam.
That has been paid. So it is not a case where we have tried to suppress or camouflage that particular 1 lakh liability as this existing liability. We have admitted that has been paid. So it's not a case where we have not come with clean hands, my lord. Now, apart from, my lord, these, the check where the presumption of 139 remains, which has not been rebutted, here, my lord, this FIR, because we had lodged an FIR against them in respect of this non-payment of money, where they also got bail, we have also exhibited that FIR as Exhibit 2, my lord. That FIR was registered as Nagaon PS case number 1092 of 2011 under sections 406 and 420. And during the pendency of the investigation of this FIR, my lord, so this settlement was reached, pursuant to which this check was issued. We have also, my lord, exhibited that settlement agreement as Exhibit 4. So the settlement agreement will also show, independent of the check, my lord, that he had agreed to the existence of that 5 lakh rupees liability, and that he had agreed to pay the same, my lord. Apart from that, my lord, this money hand note, my lord, has also been exhibited by us, my lord. That hand note where this particular amount has been acknowledged by them. Now, one of the things which they have said is that this is a point which my learned friend has also argued, that the person who had executed the hand note, my lord, he was not examined as a witness. So the attesting witness to the hand note has not been examined. Now, my lord, the promissory note or a hand note also carries a statutory presumption, my lord, under the scheme of the NI Act, under section 118. So it is not just a check, my lord, which carries a presumption. All other negotiable instruments, including a promissory note, my lord, that also comes with a presumption under section 118. So there is this presumption that this promissory note is executed for the consideration which is mentioned there in my. So that again the burden would
Burden of rebuttal is on them.
On them, my lord. So they have to rebut this hand note, my lord. We, even if we do not examine the attesting witness, my lord, because of the existing presumption, this hand note will still survive, my lord. So hand note, settlement agreement, and the check, my lord. If all of these are conjointly seen, my lord, their liability is very apparent, my lord, very evident. And another plea, one plea which they have taken, my lord, is regarding the non-disclosure of our funds or our financial competence. Capability, my lord. And again, this is a plea, my learned friend has not argued now, but it is there in their petition. So, my lord, knows that the law on this is very clear, my lord. I am required to prove my financial competence only when I'm questioned about it. So they have to question me about my financial competence, and only then I am required to show my financial competence. If they do not question me, or they do not confront me, or do not dispute my financial competence, then I am not required to prove my financial competence, my lord. Here your lordship will kindly come to page 73, my lord. That's Rohit Bhai judgment, my lord. In relevant portion, your lordship will find at page 84, para 18.
Page 84.
Page 84, my lord, para 18.
Yes.
In the case at hand, even after purportedly drawing the presumption under section 139 of the NI Act, the trial court proceeded to question the want of evidence on the part of the complainant as regards the source of funds for advancing loan to the accused, and want of examination of relevant witnesses who allegedly extended him money for advancing it to the accused. This approach of the trial court had been at variance with the principles of presumption in law. After such presumption, the onus shifted to the accused, and unless the accused had discharged the onus by bringing on record such facts and circumstances as to how the preponderance of probabilities tilting in his favor, any doubt on the complainant's case would not have been raised for want of evidence regarding the source of funds for advancing loan to the appellant accused. The aspect relevant for consideration had been as to whether the appellant accused had brought on record such facts, material circumstances, which could be of a reasonable probable defense. So first of all, this presumption will survive, and unless and until there is some material on their part, either by way of confronting me or questioning me or disputing me as to my financial competence, my lord, this plea of my financial incompetence at this stage cannot be raised to get away with the.
So they have taken it for the first time in the.
Here in the revision, my lord. It was not taken during, at least when I was cross-examined, my lord, I was never examined on this point, my lord. This law has also been reiterated by 3 judgments, my lord, because there were some conflicting judgments on this point. So page 53, last judgment, my lord. Kalamani.
Page 50?
53, my lord. Para 13. Yeah.
Yes. Para?
13, my lord.
Yes.
Adverting to the case in hand, we find on a plain reading of its judgment that the trial court completely overlooked the provisions and failed to appreciate the statutory presumption drawn under section 118M, section 139 of NIA. The statute mandates that once the signature of an accused on the check/negotiable instrument are established, then this reverse onus clauses become operative. In such a situation, the obligation shifts upon the accused to discharge the presumption imposed upon him. This point of law has been crystallized by this court in Rohit Bhai Jeevan Bhai Patel versus State of Gujarat in the following words. So the earlier judgment is, my lord, reproduced. Now para 14, my lord. Once the second appellant had admitted his signatures on the check and the deed, the trial court ought to have presumed that the check was issued as consideration for a legally enforceable debt. The trial court fell in error when it called upon the respondent complainant to explain the circumstances under which the appellants were liable to pay. Such approach of the trial court was directly in the teeth of the established legal position as discussed above and amounts to a patent error of law. So, my lord, in summary, my lord, check for ₹5 lakhs issued by the petitioner. Issuance of the check is admitted. Signatures on the checks are admitted. Check is supported by a promissory note in respect of which also there is a presumption. Apart from that, there is also the FIR, my lord, where pursuant to which they executed a settlement agreement, where again they have admitted their liability and their willingness to pay the amount. Pursuant to that agreement, they've issued the check. They have failed to rebut that burden, my lord. A plea which they have taken regarding payment of ₹1 lakh, and that 1 lakh is the actual liability amount, has not been proved by any cogent evidence, my lord. So, on these facts, my lord, courts below have already decided and found them guilty, my lord. And this is a case going back to, my lord, 2011. These NI cases, my lord, are supposed to be disposed of in 6 months, my lord. And I'm, for the last 14 years, my lord, so I'm one litigation after litigation I've been facing. So I humbly pray, my lord, the orders may be upheld, my lord.
And in your second
my lord, I am seeking, because the compensation which has been awarded is
not double.
Not double, not even, my lord, is how to say it, my lord, 150%, my lord. It's only 6,50,000, my lord. Check amount is 5 lakhs. So they're under law, they are liable to pay 10 lakh rupees.
But whether that plea can be taken in revision?
The quantum of compensation can always be challenged, my lord.
Okay.
My lord, and the thing otherwise, my lord, because that is the maximum. So ordinarily one would not insist that the maximum amount should be paid. But considering the fact that this has been going on since 2011, now it's 2025, my lord, and I'm yet to receive anything, my lord, from their end. That is my humble submission that some enhancement may also be made to the compensation.
Any reply?
My lord.
I'm pressing on those grounds, my lord.
Okay. Heard Mr. D. Bora, learned counsel for the petitioner in
Item 45.
Criminal revision petition number 159/2017, as well as for respondent in next item, respondent in item number, respondent in criminal revision petition number 445/2017. Also, Mr. S. Nawaz, learned counsel for respondent number.
Respondent number 2 in criminal petition number 159.
Who in criminal petition number 159. As well as
petitioner in
criminal revision petition number 445/2017. Hearing concluded, judgment reserved.
Obliged.
I must say. You are ready?
I have had it at 2 minutes.
Also, it may be taken next week. Today, passed over for the day.
This is,
What is the matter?
Petition.
they have filed a petition for quashing of the NIH case.
Quashing?
Quashing.
NI case.
Yes, we'll hear it.
Lordship, actually engaged counsel actually had to leave, your lordship. It is also today little bit difficult. Next week, your lordship, on 10th or 11th, any day.
10th, 11th, lordship, it will be difficult for me.
Suggested
I
it.
may not be able, not sure. now.
Then suggested it.
Yes.
Who is conducting this case for the petitioner? You are not conducting.
I'm there, but H. Ali is mainly conducting.
H. Ali.
He was there, but he had to leave due to
Okay.
urgency.
Maybe 16 if they are saying, had it been in the morning,
Since morning, we are
We are
waiting for this
waiting for
matter,
this.
and your lordship, he did not inform it earlier on, also, your lordship.
You should have informed.
He was there, your lordship, actually, but he had to leave.
That cannot be a ground, your lordship.
On 16,
We
your
have
lordship,
waited,
okay.
for the whole day.
Whole day.
And that is not.
And already evidence has been almost over there. That means,
Already in the lower trial, your
There
lordship,
is no stay.
no stay has been granted.
they are proceeding with the trial, your lordship. As per the records also, your lordship, I have seen your lordship.
Suggested it.
Lots, one, just I point out one thing, not on this case, lots of procedural part, what trial courts have self-imposed. I am on the concern on that line. This case has been admitted on 12/3. PW was cross-examined, another PW was present. The order reflects like this: Mr. S. Sharma for Bank of Baroda, Bongaigaon Town branch is present today to depose evidence. However, since one criminal petition.
This
bearing number
order is
35
of trial court.
I am reading out just.
Trial court,
concerned-
sir. Trial courts.
order, Not in record. Lots.
Okay.
Beyond the record. Lots. I am concerning about the procedure adopted. The going on, what going on before the trial court.
Yes.
However, since one criminal petition bearing number 3525 filed by the accused before Honorable Guwahati High Court for quashing of the proceeding of the instant NICR case is pending adjudication in my considered opinion, since the said matter is sub judice and yet to be decided on, I do not deem it appropriate to proceed with the trial court instant case until receipt of the appropriate order passed by the Honorable Guwahati High Court. The proceeding of the instant case accordingly stand stayed until then.
Self-imposed.
This is the self-imposed part. This is a dangerous.
No, that should
procedure.
have been brought to the notice of High Court by one of the parties.
No, I have under impression that yes, it is totally over, so I am not wanting to.
Yes, yes, this
on record.
this may be clarified in this case. You choose the date,
Maybe on 16th, lots,
16 Paribu,
if possible, lots.
Amar Vidhamati log, so that it
10th, 11th, lots of, it
no,
may be difficult.
again 10th, 11th, we have lot of,
No, that's why
this
it's also I may
court
not
is
be there.
taking up bail
So,
matters.
Lots of, as per lots of convenient.
Iman. Correct, so this 15th October.
First,
16th October.
Was it September? before-
September,
16th September or
16 September, you have to wait till 4 and then you will say that your colleague has gone. So,
Today, he was there also.
heard,
16th.
no.
I
Heard
have
Mr.
restriction on any day, that's it, except.
What
this
is your
10 and
name?
11th part, I may not be.
R.
More.
Kaur. Heard Mr. R. Kaur, learned counsel for the petitioner. Also heard Mr. S.K. Poddar, learned counsel appearing for. You are appearing for sole respondent.
Responding.
S.K. Poddar. Okay. As well as Miss P. Das, learned Amicus curiae appearing for sole respondent. Learned counsel for the petitioner submits that due to some personal difficulty, Mr. H. Ali, who is the conducting counsel for the petitioner, had to leave early from the court, and on that ground an adjournment is prayed for. Considering the submissions made by learned counsel, the prayer is allowed. Let this case be listed on 16th of October.